two persons stated that they were asked by the police.
বললো এটা কি করেছো তোমরা? মেন ম্যাটার, মেন লিস্টে জলপাইগুড়ির অজস্র মামলা ঢুকে বসে
জামিন দিয়েছে।
ইয়েস,
Judgment. My lord, the ratio is that, my lord, will kindly seize this judgment. My lord, it clearly states that where it is, sir, একটু judgment টা দিন আপনাকে দিলাম।
কপিটা কই? ওখানে দিবেন।
হ্যাঁ। My lord, it clearly states that DK, my lord, following the ratio of the Supreme Court judgment in DK Basu versus State of West Bengal, my lord, there must be one independent witness. Section 41B speaks as such. My lord, this is section 41B of CRPC.
এটা অফিসার ইনচার্জ এটা এসআই, এটা এসআই
And my lord, the Justice Shobhasachী Bhattacharya that I have handed over to your lordship previously on the first occasion.
41 is not complied with.
Yes, my lord, here is also that.
Judgment of Justice Orijit Banerjee and Justice Partho Sarathy.
My lord, that I do not have.
If I have not mistaken, there is also a judgment of Justice Bagchi sitting with Justice Suprago.
My lord, so here in this case where the seizure is without any independent witness and I'm in custody for 7 months.
Let us take the example of section 50, where you require a gazetted officer to be there. But section 50, subsection 5 says that if there is a situation that where you cannot have, you suddenly receive a flying message, you intercept. Will you search for a gazetted officer to put his signature, or will you confiscate the goods?
My lord, that is the
On that
requirement of the
score-
statute.
On that
That is the
score, Justice
requirement of the
Bagchi,
statute.
Justice Bagchi has already delivered judgment.
Yes.
That is to be considered. Let the
Well-
matter be placed before the regular bench.
My lord, I have filed it before the vacation bench. My lord, let it be decided here.
No. How? All the
Well, let
judgments
it be
considered
decided
subject to
here.
correction.
Take down.
Yeah, it was totally a blank space, but here they are
That That is a seizure list that I have placed. And lordship sees the memo of arrest. It is blank.
In this
তারপরে judgment এসেছে, জয়মান্য করছি।
application for bail,
I'm deeply obliged to you.
the petitioner
আমার নাম দিও না।
alleges that
My lord, will kindly,
the seizure took place in the absence of an independent witness.
No.
Yes, yes.
Alleges.
তোমার চার্জশিটে দেখো এদের কোনো অস্তিত্ব নেই।
The petitioner relies upon two decisions. One passed in CRM bracket NDPS 1770 of 2023 ব্র্যাকেটের ভেতরে in the matter of Fayaz FAIYAZ Alam alias Fayaz FAYAZ Alam versus
জাজমেন্ট কে বলতে জাজমেন্ট বলতে আরে ফ্যাক্টস আলাদা ওই যেটা বলছে তার সাথে
My lord, may I interrupt your lordship for a moment? My lord, if your lordship kindly dispose of the application by directing the trial court to conclude the trial within a certain period of time. My lord, that will be
so
my
you have raised a legal point. Let it be addressed.
my lord
my lord, without going into my lord, that let that point be kept open to be decided at the point of trial.
Too old a campaigner for this. Too old a campaigner for this. When you could not succeed, you are trying to.
No, my lord, never that. My lord, let this
number
point
কি
be left open in the trial.
না প্রবলেম
What will the trial court?
প্রবলেমটা কি
If there is a conflicting view in the High Court
My lord,
judgment,
after trial, my lord, at the time of argument, my lord, let the trial be concluded within a certain period of time. My lord, within 6 months, because I'm already in custody for
কি বললাম? State and submits that the seizure is in violation of section 41 within bracket small b of the Code of Criminal Procedure 1973, in short CRPC. And as such, the entire action is vitiated.
my lord.
There are conflicting views in this issue. The matter requires to be heard. Let this matter be placed before the regular bench, subject to its convenience.
My lord. না একটা সার্টেন টাইমের মধ্যে ট্রায়াল হয়ে গেলে হয়ে যেত অ্যাজ ইউর লর্ডশিপ
ওই সিজার লিস্টটা ওকে ফেরত দিয়ে
আই এম গ্রেটফুল টু লর্ডশিপ my lord, may I take back the judgments or my lord it will be
you take back.
judgment
I'm not pressing this application, Your Lordship.
Why?
Our client did not want to proceed this case, Your Lordship.
Want to proceed?
Yes, Your Lordship.
Pay cost. Pay cost. Subject to payment of cost. Assessed at 100 gold more. Payable to the state legal services authority and to be kept earmarked for the welfare of POXO victim. The application is allowed to be withdrawn.
I'm grateful. Lordship, kindly consider it, Your Lordship.
কেটে দাও ও কালকে ও চলে যাবে the ask for doesn't want to press this application, thus the same is dismissed as withdrawn. But I wish I should impose cost. I know in bail matters this cannot be done, but I wish I could. These are chance litigations.
My lord, I am for the petitioner. My lord, this is my renewal of prayer for bail after 21st of September 2023. My lord, the petitioner is already in custody for about 2 years, since 3rd of November 2021. My lord,
What is the contraband?
my lord, 5 liters of codeine mixture. My lord, the reason why I am renewing is only on the ground of detention. My lord, after my prayer for bail was rejected in September, I have annexed.
Yes, after 21st, what are the new grounds?
Yes. My lord, after that, on 12th of October,
What you, Mr. Ganguly,
my lord,
what did you hand over?
Judgment, copy of the judgment.
my lord, that I have already annexed in the petition. My lord, on 21st of September,
21
it was
2023.
yes. My lord, my detention, my lord, this detention was only because of non-submission of the chemical reports.
So that has
Chemical
been
examiners,
submitted.
it has been submitted on, my lord, 21st of September. My lord, thereafter on 12th of October 2023, my lord, this was a view of this honorable court on 12th of October after rejection of my prayer for bail. My lord, where the petitioner was in custody for 1.5 years, and since chemical report was submitted on a belated stage,
Yes.
this
Bakchi's
honorable court,
judgment. Bakchi's judgment.
yes,
What? 5 liter?
my lord,
5
my lord,
liter?
2 years in custody.
কেসের স্ট্যাটাসটা বলো
To be very candid,
একটাও সাক্ষী হয়নি।
to be very candid, 5 liters is found with a peddler. He is not a consumer.
Well,
If he was a consumer, then by this time he would have
No, no,
suffered
my-
from
my lord,
retracel syndrome and would have landed somewhere else.
my lord, I am only in custody.
Let the
No, you
society,
see, these
let the
judgments
society be in
in the
peace.
subsequent 12/10/2000.
Yes, my lord, which is why I filed this application.
Chemical report
Trial
was
started
also
not
before
the date
the
of evidence
honorable
of the-
bench. You see, on the last occasion, this chemical report was also before the bench.
Yes,
Okay.
yes.
The honorable bench thought fit to reject.
Yes,
So now, after the honorable bench has rejected, how can we reopen the
Thereafter,
issue?
my lord, then will your lordship will kindly,
Or you can take
Well,
your chance before the regular
my
bench.
lord, will kindly give the 6 months.
application. Why
My lord,
regular bench lordship?
Arey, দাঁড়াও
Reject
না।
this
My
application.
lord, 6 months time
They
to,
rejected.
Yes.
my lord, time to conclude the trial within 6 months.
That we go. No, no,
My
that
lord, that
cannot be.
indulgence, my lord, otherwise in Pujo vacation, my lord, we will have to go without any take away, my lord.
না, না,
Expeditious trial দেবেন, ঠিক
আমার
আছে?
কাছে তো 6 সাল।
অর্ডারটা আমি বলে দিচ্ছি। After hearing the parties and considering the materials on record, we do not find any change in situation after rejection of the last
My lord, let it be only rejected without any direction there.
application for bail. The accused was intercepted with 5 liters of codeine mixture.
My lord,
The chemical report has already the chemical report was already there before the court when the last bail application was rejected. After considering these factors, we do not find. After considering these factors, we do not find any reason to enlarge the petitioner on bail. Let the trial
my lord,
Trial started, Lord. Trial started.
since the trial has already started, let the trial be concluded as expeditiously as possible.
my lord, preferably within, my lord,
No, no, Lord.
my lord.
As expeditiously,
Yes.
you know how the courts are burdened. as expeditiously as possible without granting unnecessary adjournment to either of the parties.
Grateful. I'm grateful, Your Lordship. Reading. My lord, I appear for the petitioner.
But
Well,
twice rejected.
Item 6.
Six.
My lord, I am for the petitioner. My lord, let me get the privilege to address your lordships first.
But twice rejected.
My lord, this is my renewal of prayer for bail. These are ladies. We are in custody for 1 year and 10 months.
What is
What-
the
what the
amount
7
confiscated?
kg of codeine.
7 kg, possession, 1 year, 10 months in
And your evidence started. Only one witness examined.
in absence of any gazetted officer.
50
That is the matter of trial.
My lord, I should point out before your
That is the
lordship.
matter of trial. Not subject to correction.
My lord,
এটাও ইয়েতে অর্ডারটা করে দিচ্ছি দেখুন।
নাম দিয়েছি?
The accused was intercepted with
7 kgs of 7 kgs.
codeine mixture,
Phosphate mixture.
codeine phosphate mixture of about 7 kg.
লিখে নিচে পুলিশ
The petitioner says that
Petitioners, my lord.
there
petitioners, two petitioners.
the petitioners, ঠিক আছে? The petitioners say that there is a violation of the provisions of section 50 of the Narcotic and Psychotropic Act 1985, in short NDPS. Full stop. Right? In as much as the seizure took place in the absence of a gazetted officer. Full stop. The requirement of seizure in the presence of a gazetted officer is not a mandatory requirement of the provisions of section 50 subsection 5 50 ভেতরে 5 of the NDPS Act. Considering the materials on record, the quantity seized here of the we are not inclined to enlarge the petitioners on bail. The application is accordingly rejected.
my lord, expeditiously.
Since the trial has commenced, as expeditiously as possible. যেটা আগের ইয়েটা
I'm grateful, Your Lordship.
Deeply মানে obliged to lordship.
অংশুমান চক্রবর্তী।
Item number 6.
But 6 lord, I appear for the state with Mr. Ganguly.
Petitioner does not want to proceed with the instant case, my lord.
একই
Grateful, my lord.
Does not
আগে
want
একটা
to
দিলাম না যে doesn't withdraw.
সাত নম্বর তো অশোক আছে তো অশোক।
Item number 7.
But 7 lord, I appear for the state.
I am for the petition. My lord, the petitioner is in custody for 5 years, 3 months. Case, my lord, commercial quantity NDPS. 510 kg of ganja was recovered from the possession of the petitioner as also other petitioners. Total 4 petitioners. My lord, kindly have a look into seizure list. My lord, page 43 onward.
But 3rd April, you are rejected by the
Please
regular.
allow me, please allow me.
43 is a seizure list.
Yes, my lord, page 43 onwards, my lord, scissor lift. My lord, I have not suppressed anything. Page 12, the rejection of the present petitioner on 22nd January 2021. My lord, Amjad Ali Khan, my name is. I am a national level football player. Everything I have annexed, my lord. My lord, what has happened?
Does it give you a license to deal with?
No, my lord.
520
No, my lord.
kg.
Lordship, kindly.
520 kg ganja.
Yes, my lord, I have stated. My lord, recently, my lord, during vacation, one of the co-accused granted bail on the same footing from him, my lord, same from the truck, my lord, granted bail by this honorable court, pursuant to the judgment of the honorable Supreme Court. My lord, recently Justice my lord Surjakant and Honorable Justice Dipankar Datto passed an order regarding my lord conflict between 37 and Article 21. Here in the instant case, charge was framed on
Out of
10
9 452 witnesses, 5 witnesses have already.
yes, co-accused granted bail. That order, my lord, I handed over.
Like the order which you handed over because you lost it. But
Co-accused
No, no.
granted bail in the same footing. I handed over the order.
Milord, may I join the issue? May I join the issue? May I join the issue? The convenience of the court. What has happened? The order which is allowing a person who is similarly situated like petitioner, Lordship, I see on that date, this was not placed before this honorable court.
That is not, that is done.
Defense has taken time. Lordship, kindly submit the person.
My lord, 5 years.
The only ground that the prosecution has delayed the trial, that's why granted bail. Lordship, that is
Allow me. If your lordship prosecution not allow me, then
For how many years?
my
I
lord,
be of 2 months.
It's a long period.
nine examined.
And my lord, honorable Supreme Court order.
5 witnesses examined.
Honorable Supreme Court
And
order.
If both of you
My lord,
speak at
I'm
the same
sorry, I'm
time,
sorry. I tender apology.
If the
I tender
prosecution suppress me, then my lord, kindly adjourn my petition, my lord. They suppress me.
April
My lord,
2023
My lord,
rejected.
lastly, honorable division bench granted bail to one of the accused who, my lord, arrested on the same day, 5 years, 3 months.
what is his nexus? He may have been arrested. What?
Same footing, my lord.
what-
Kindly come to page 43, nexus. Page 43, my lord. In the middle portion, E, Harpreet Singh, Amjad Ali Khan, Balvinder Singh, Amit Rai. 4 accused person, my lord, arrested from a truck, my lord, in the year 2018.
They are charged under the same sections.
Same section.
They are charged under
Yes,
the
my lord, same section. Charge, page 88.
But he wants parity. He wants parity.
they are charged under.
No, parity. He wants parity because one person has been granted bail by the court.
Look into page
Before the possession bench, he wants the parity. Lord, on parity, Lord, I am submitting. Lord, that was not placed.
Which one?
I have handed over.
The accused has been enlarged in bail, not on the materials on CD, but on the delay of trial.
হ্যাঁ
এটাই হচ্ছে ground.
Well, how
Yes, the prosecution has taken time, but that is not the fact.
It is an admitted position that the case is pending for 5 years. He is in custody.
No, that was not my lordship. Kindly see the not pending. Why? That is the reason.
Due to his fault.
Yes, that is the I have handed over. Not adjournment by the. Well, kindly. Court has asked the question. Kindly.
Yes.
Lord, the adjournment by defense. 15th of February 2020, 11th of February 2021, 6th of March 2021, 18th of September 2021, 18th of February 2022, then the 8th of July 20.
By which accused person?
Yeah.
Defense.
No, which defense? This petitioner or other petitioner?
Accused persons. But then, Lord, I have to produce the certified copy.
all certified copy I annex.
Okay. Yeah.
Page 58 onward.
don't get excited.
All certified copy I annex, my lord.
Your other side may have antagonized you. We have not antagonized.
Get fully over.
honorable bench was not on the basis of CD, but on the basis of his detention and the delay in trial. So this is
Delay in trial, that is not Lordship kindly see me what is the observation of the honorable bench.
They are wrong submission.
Lordship kindly see the observations
whatever
that the prosecution has delayed the trial. That is not the fact.
One by one, kindly have a look into the order sheet, page 115, order sheet.
Which date? Which date?
5th August 2023.
No, where? Huh?
All order I annexed.
Yes, fifth other orders have not been annexed.
Yeah, all
These orders have not been annexed. If my understanding is shouting, Lord, I am keeping quiet. Your Lordship will ask me after his finish.
there are 11 witnesses. How many witnesses?
Nine witnesses, 5, 8, 5 already examined.
We want to borrow earbuds from you.
Normal voice tolerance. But out of 5 witnesses already been examined.
Not 8, 10, page 51. Kindly have a look into page 51. One by one, my lord, I have annexed all the documents.
Very
Page
well.
51.
Take your seat.
Yes, my lord.
Yes, annexed,
Kabar bolbe.
but not annexed in this order.
All order I annexed. Page 51, charge sheet witness, 10. Out of 10, 4 fully examined and 1 partly examined. Then kindly come to page 58 onwards. All certified copy I annexed from the very beginning. 19th July 2018, petitioner was produced before the London Special Court. Thereafter, all order I annexed. Till 30th September 2023, 115. Kindly have a look into.
Just a minute. Just a minute.
But kindly see the orders today.
All I annexed, my lord, page 49. All the orders I annexed. Kindly come to page 115, 114.
Let us look into the order. Don't strain your voice so much.
113. Today is fixed for evidence. Both party present. Prosecution takes step. 112 also.
Your lordship. It will help your lordship.
My document certified copy. All document I annexed, my lord. 112. Today is fixed for evidence. Both party present. One witness is present. On the prayer of the London prosecution, case is adjourned. 112. Thereafter came to page 111. Then 110. PW4 is examined, fully examined and discharged. No other witness is present.
Take down.
And my lord, kindly consider the Supreme Court judgment.
The manager, we are granted. See, no, see, we are not here to blame who has taken, you know very well how adjournments are taken. No need to elucidate that. But the difficulty is that has been in custody for more than 5 years. No custodial detention is required for investigation purpose. Witness action is already being there. Now, there is also very limited, I will not say that there is no chance, but very limited question or chance of him influencing the trial. At this stage,
But Lordship kindly consider. And these on coordination consider the delay in trial. Delay caused by the prosecution. But that was not placed properly. But I
will record you.
But I have come to the certified copies and on the date. Lordship kindly see not only 1 or 2 days. Blood minimum blood 10 to 12 days. They took the time to delay the proceeding, only to wait for the regular.
That is not correct.
delegation.
That is not correct.
Thereafter, your lordship kindly consider 520 kg. Yes, 520 kg is gone. And 37 is there. Lordship kindly.
It is only discussed by Justice Dotto.
Why are you? Lordship kindly see 3rd April. His Honorable Court rejected on the same footing.
We're in same footing.
Lordship kindly.
But that I have annexed. I already stated.
Lordship kindly see. Kindly see, Lord, that.
This is a month of April.
Month of April.
Okay, and now we are in the month of November.
Take down. Take
Take down.
the other. Your colleagues will now curse you.
Not 5 witnesses examined thereafter.
Very, very.
And December is the date. Lordship kindly.
The accused, along with 3 or 4 others,
My lord, 4 accused persons.
along with 3 others, were intercepted with 520 kg of codeine mixture.
But
Gaja.
not quoting Mr. Gaja.
Gaja. Yes, yes, ganja.
510 kg of Gaja.
Ganja. And is in custody for over 5 years. One of the co-accused has been granted bail on bail on 26th October 2023. Full stop. The records reveal that out of 9 witnesses, 5 witnesses have been examined.
4 fully, 1 partly.
4 fully and 1 partly. The coordinate bench on 26th October 2023, while considering the application for bail for the co-accused, has taken into account mainly the delay in trial. On behalf of state, it is submitted that the delay in trial has predominantly occurred due to adjournments being taken on behalf of the accused persons, including the petitioner, a co-accused. Full stop. Without going into the reasons for adjournment or the grounds thereof, we find that the trial has proceeded to a considerable extent. There is, as such, no requirement of the petitioner to be detained for custodial interrogation. There is also a minimum likelihood of the petitioner influencing the trial if enlarged on bail as four witnesses have already been examined.
Five examine out of it.
No, he says four,
Four part, fully, one partly.
and the fifth witness has been partly examined. Full stop. The provisions of section 37 in the facts of the case 37 of the NDPS Act পুরোটা দিয়ে NDPS করবে according to us in the facts and circumstances of the case gets whittled down. Full stop. The petitioner is accordingly enlarged in bail. ওটা কি দেবেন এটা দিন হচ্ছে হ্যাঁ ওটা দেবেন হচ্ছে on the following condition, ঠিক আছে? Two sureties of rupees 10,000 each, one of which shall be a local. The next B, the petitioner shall not leave the local jurisdiction of the police station without intimating the IO. In না পরের দিন হচ্ছে ওসি অবলিক আইসি of the concerned police station. তারপরে হচ্ছে the petitioner shall cooperate with the trial and shall be available before the court as and when required. Full stop. As and when required. In default, the bail granted herein may be cancelled. The two sureties subject to
Satisfaction CJM Alipur. CJM Alipur.
CJM. পিটিশন তারপরে হচ্ছে ঠিক আছে
CJM Alipur.
ঠিক আছে আর কিছু ওইটা হলো তো তারপরে আনমার্ক প্যারাগ্রাফে দেবেন এগুলো 1 2 3 করে দিলেন তো তারপরে ইয়েতে the trial be concluded as expeditiously as possible. You know,
in all cases we are giving that expeditious trial. In other all cases also we are granting expeditious trial.
Exceptional case, but 3 witnesses only. I pray,
trial.
Mr.
this is your lordship. Not only my paper, within 6 months. I visit your lordship, because bail has been granted by 6%. And your lordship know the NDPS case.
আপনি ভালো বলতে পারবেন
5 years এ পারলো না সমাধান।
You all know the NDPS case 99% acquittal.
expeditious trial without granting unnecessary adjournment to either of ওটা যেটা থাকে আর কি যেটা দিচ্ছি আর কি expeditiously without granting unnecessary adjournment to either of the parties.
May I take back the certificate?
Yes, you take back all things.
আমার জাজমেন্টটা দিন না। Grateful, your lordship. ওদিকে চলে গেল সব আমার।
So I am for the petitioner.
My lord, I am what is stated.
Lordship, in this case, on 21st of February, petitioner was apprehended by BSF personnel with 40 bottles of fentanyl at 6:15 p.m. in the evening. Now, on the next day, on 22nd, at 8 a.m. in the morning, this FIR was lodged with the police station. Now, if your lordship see the seizure list shows place of seizure at the police station. Seized from whom? From BSF personnel.
My lord,
How custody basically?
My lord,
How many days custody?
Lordship, I am in custody for 255 days.
ওই এটা ইয়ে হলো বেল গ্রান্টেড ওই একই কন্ডিশন গুলো থাকে।
my lord, 40 bottles fentanyls were seized from the petitioner and another person, my lord.
Not a peddler. Maybe consuming and
My lord, they
distributing
are
among the
habitual,
friends.
my lord, they are habitual offender, my lord.
Other antecedents are there. Lordship kindly consider.
My lord, they were moving
Regular bench-
suspiciously, my lord.
regular bench হয়েছে।
রেগুলার বেঞ্চ অ্যান্টিসিপেটেবল গ্রান্ট করেছে। আমি অর্ডারটা অ্যানেক্স করেছি।
তাদের কাছে
Well, antecedents.
I have been granted anticipatory in
With regard to another case.
another case. Granted
The
anticipatory.
antecedents are there.
The petitioner was accused was intercepted with 55 bottles of
40.
40 bottles of
fentanyls, my lord.
fentanyl
My lord, they were trying to
cups. হ্যাঁ বলো তো and is custody for about 255 days. Trial?
Not
report?
charge sheet submitted.
charge sheet submitted.
Charge sheet submitted.
Charge sheet has been submitted, but the trial is yet to be.
Commitment হয়নি তো। Charge
commitment.
framed হয়নি।
My lord, charge was not framed, my lord.
Is charge frame?
Charge sheet submitted.
Oh,
Charge sheet submitted, but charge has not been.
yes, yes.
So you are the sole accused.
Sole accused.
কি বললো?
No, my lord, another.
But
My lord,
the charges have not framed.
No.
Charges have not yet been framed. As a consequence
two
whereof
persons
the
have been classified.
trial has also not commenced. Considering the quantity of the contraband seized and that the charge sheet has already been filed, we do not find that the detention of the petitioner is required any further at this stage for custodial interrogation. ওই 10,000 যা একই, হ্যাঁ
সিজেএম বহরমপুর মুর্শিদাবাদ। সিজেএম বহরমপুর মুর্শিদাবাদ। গ্রেটফুল।
না ওই যে কন্ডিশন গুলো দেওয়া হয়েছে না, হ্যাঁ সবগুলো দিয়ে দেয়। ও শুনুন, আপনাদের অভিজ্ঞতা আছে তো, কালকেই আবার আরেকটাতে
নিয়ে যাও।
My lord, I'm for the petitioner, my lord, Mr.
My lord, I am appearing for the petitioner, my lord. My lord, I am appearing online, my lord. My lord, I would humbly beseech your lordships to grant me a day's accommodation, my lord. Mr. Debashish Roy was leading me in this matter, my lord. My lords would be aware yesterday by a notification, my lord.
in go before the regular bench.
I just rejected twice, rejected commercial quantity.
No, my lord, we have enough points, my lord. There are violation of mandatory provisions.
Because now there is a change in the situation.
Let him go to the regular bench, Lordship, because you are wasting our time.
My lord.
Since the senior counsel engaged in this matter is not in a position to appear any further, let this matter placed.
My lord.
না সেটা করবেন কি as submitted
My lord.
by the petitioner. The senior counsel engaged by the petitioner is not in a position to appear any further in this matter. Let the same be placed before the regular subject to its convenience.
Grateful.
Next time, also.
1 year and 6 months, the present petitioner is in custody. He was arrested on 29/5/2022 for allegedly possessing 2.5 kg of codeine mixture.
For the commercial quantity.
No, that's right. But my lord,
it is twice
out of
rejected. Don't waste our time, Lordship.
Let me submit.
No,
Let
you
me
are submitting
submit
it
first. I am for
every
the petitioner.
vacation means.
Yes.
I am for the petitioner.
Let him get the satisfaction. He wants to address, let him get the satisfaction.
Not actually.
Otherwise, he will go out and have a feeling that the court did not allow him.
He has done so many cases during the 2 benches in these cases. It's not the only one.
Yes.
My lord, actually, my lord, here, my lord, when the search and seizure was made, no independent witnesses were present there. And to that effect, my lord, no explanation was made from the side of the investigating agents. My lord, second point is, my lord, after rejection of bail from this Honorable High Court, my lord, I moved an application before the Honorable Supreme Court. Kindly have a look into the matter said order. That is, my lord, at page 9. At that time, my lord, 4 witnesses were examined, which was mentioned that though it was mentioned for 2, but it was 4, my lord. We are not inclined to interfere with the impugned order of the judgment, and hence the special petition is dismissed. However, it will be open to the petitioner, Munil Rajok alias Munilal, to file a fresh application for bail.
What is the change in situation?
Thereafter, and another point is written here. For bail in case of change in circumstances or if the trial gets prolonged. Thereafter, 3 schedules were fixed. No witnesses.
Take down.
No witnesses turned down.
Take down.
My lord, kindly see, my lord, out of 12 witnesses.
The accused was intercepted.
1 year and 7 months I am in custody, my lord.
Was intercepted with
to the petitioner
2.3 kg codeine mixture and is in custody for about 1 year.
1 year
Yes.
and 6 months.
6 months only.
Is in custody for about 1.5 years. The accused had moved a bail application before this court, which was rejected. Challenging such rejection, the accused went before the Honorable Supreme Court of India. The challenge by the accused, however, was turned down, granting liberty to the petitioner to file fresh application of bail in case of change in circumstances or if the trial gets prolonged due to reasons not attributable to the petition.
This is my ground, my lord.
The petition, after hearing the parties and considering the materials on record, we do not find any change in situation from the change in situation from 5th July 2020.
Yes, my lord. Change is there, my lord.
When?
My lord, after 5/7/2023, my lord, 3 serials, 3 dates were fixed.
If we
No
allow,
witnesses turned down.
if we allow you to make submission, we are sure you will continue till 4:30.
Yes, my lord.
If we allow you to make submission continuously, we are sure that you are capable of doing continuing the matter till 4:30. Now in bail petition, we don't have that much
No,
time.
that's not, my lord. That's the matter. My ground is, my lord, as the point.
Please do not interrupt while we are passing the order.
And only 1 minute can be allowed. Only 1 minute. My lord, as the
I have spoken in clear English. What is the change in situation? Tell me.
Change or here, my lord, one point is there or if the trial gets prolonged due to reasons not attributable to the petitioner.
It is our incompetence that we do not understand the English.
So there are 2 points. One is change in circumstances or if the trial is prolonged.
Don't invite us to use harsh comments. Did you follow the order?
Yes, madam.
Did you follow the order?
Yes, madam.
What has been recorded?
That has been recorded.
Then?
Kindly, madam, I am submitting, madam, as madam.
Don't make unnecessary submission.
Considering the materials from the report, we do not find any change in situation from
July 2023, when the order of the Honorable Supreme Court was passed. Full stop. However, the petitioner says that after 5th July, 2 dates were fixed for the trial, but it got adjourned due to non-availability, adjourned at the instance of the prosecution. Thus, the second limb of the order of the Honorable Supreme Court, that quote unquote, if the trial gets prolonged due to reasons not attributable to the petitioner, is attracted, and as such, the petitioner should be granted bail. Full stop. Only three months have elapsed.
Date fixed already. Next date fixed.
In between. And the court have proceeded for the annual vacation. It therefore cannot be said that it cannot therefore be said at this stage that the trial has got prolonged due to reasons not attributable to the petition. The next date has
6/12 and 7/12
been respectively fixed on 6 December
and 7/12 of
December
2023.
2020. Full stop. In the facts and circumstances, as aforesaid, the application for bail is rejected.
Grateful to Lordship.
We are not that dumb. I may not be taking up criminal matters, but don't try to
No, Lordship.
make me understand
no,
the
no,
Sixth sense of Lordship. Please.
My lord, kindly, my lord, my another prayer is, my lord, kindly these 2 dates, that is 6 December or 7 December should
That
be
can
utilized.
Lordship not very
Should
much
be
will
utilized. My lord, otherwise, my lord,
trial court.
otherwise, my lord, the evidence will not be, my lord, done.
No, you are already protected by the order of the Honorable Supreme Court.
My lord,
So
that
that is binding
is not
upon the
followed.
court.
That is not being followed by the learned trial court. That is why, my lord,
Whether it is followed or not.
I-
In a lighter vein, there is no requirement of a booster dose. Supreme Court has already given the dose.
I appreciate Lordship. The first instance, you have followed the section 50, subsection 5. I am very much happy, Lordship.
reject হলে তোমরা তো happy হচ্ছ। সেটা বলা যায়।
11 Lord, I appear
Item
for this.
11, I am for the petitioner, your lordship. My lord. My lord, the prosecution case is that, my lord, the petitioner was traveling on a bike. He was intercepted at Malda and 305 grams of heroin was recovered, your lordship. My lord,
Brown
my case
sugar.
is that the seizure of the case is completely doubtful, my lord. I am covered by the judgments passed by this honorable court, my lord. Firstly, my lord, Justice Bakchi passed his judgment that is on 22nd of June 22 that it
এটা
will
দিন
be
তো
videographed, your lordship.
এটা নিয়ে নেবেন
It has not been videographed.
জয়ন্ত বাবু
There is no videography of the whole search and seizure, my lord. There was a complete direction by this court, my lord. After that, my lord, the question of independent witness was there. It was late in the night. There was no independent witness in the case. Lastly, my lord, section 50 should be a gazetted officer, my lord. Though he informed his IC about the whole incident, but he never informed his IC to come at the spot and to attend the seizure. So next, section 50 was also not
দিয়ে দাও জজ সাহেব
complied.
জজ সাহেবকে দাও ভাই
Before the regular bench.
My lord, as
certification has already been done before the land magistrate page 90 to 98 your lordship the witness
regular bench.
The petitioner seeks
Regular.
bail on 3 grounds. On the following 3 grounds. The search and seizure was not properly videographed, which is in violation of the statutory requirement. Which is in ওটা ছেড়ে দিন, ওইটুকু ইয়ে করে দিন, ওটা দেবেন না, ঠিক আছে? ভিডিওগ্রাফ, ঠিক আছে? 2, there was no independent witness and as such there is violation of the provisions of section 41 within bracket small b of the Code of Criminal Procedure 1973, in short CRPC. 3, there is violation of the provisions of section 50 of the narcotic purota diye tarpor NDPS Act, in as much as no gazetted officer was present at the time of seizure, full stop. These next unmarked paragraph, these issues. Now, there are divergent views on these issues. And as such, the matter requires detailed hearing, which is not permissible before the vacation bench due to paucity of time. Let this matter be placed before the regular bench, subject to its convenience.
I'm obliged to
NCB.
I appear for the petitioner, my prayer is a renewal prayer. It was turned down by the regular bench. I will be arguing on the issue that constructive res judicata is not applicable in criminal proceedings. If your lordships wants me to hear, my lord, I am regular bench, my lord, otherwise, because I will be taking up a point which was not taken up before the regular bench, which entails to my benefit. I mean, very candid.
My lord, the matter has been fixed for witness action now. Only 5 or 6 witnesses.
On bail in this case. And nothing was recovered from my possession. No. One of the co-accused has been released on.
Okay, from you nothing was recovered.
No.
So you are implicated on the basis of statement of co-accused.
Co-accused, I was served a section 67 notice. I complied with it. While I was being examined, I was arrested.
How many accused persons are here?
Total 4 millions.
And one of them is on bail.
One of them against whom, who was on a similar footing with me, from whom nothing was recovered, has been enlarged on bail. But I have been very candid about the situation.
Annex that order.
Yes, Mills. Yes, we have annexed that.
applicable হবে কিনা exactly want?
A mandatory provisions of 52A of the NDPS Act, which deals with sampling before the learned magistrate, was not done in accordance with the law or the directions given in the Mohanlal case by the Honorable Supreme Court. This was something which I should have raised while
we want that, we have to send the matter to the regular bench because there is no scope to hear all the.
That is the reason I was very candid at the first instance.
After hearing the parties, we find that the matter requires detailed hearing, which is not permissible before the vacation bench due to paucity of time. Let this matter be placed before the regular bench subject to its conclusions.
Extremely grateful.
My lord has remanded to regular bench. I'm grateful.
My lord, I'm for the petitioner. My lord, allegedly 49 bottles of cough syrup has been recovered from this petitioner. Now, my lord, the case is that the
how many days?
My lord, 500 days in custody. Yeah, my lord. My lord, the case is that the BSF personnel had this is a station seizure case, my lord. The BSF
Mr.
personnel.
Ganguly, what do you say? 500 days, 55 bottles? Maybe
Trial has started, charge has been framed.
My lord, the
Schedule has been fixed. 22, 23 and 26 of February 2024. Schedule has been fixed.
so. How many witnesses are there?
Not 8 witnesses are there. Seven witnesses, out of which none has been examined. And the next day,
It will take some time, February, from the month of February.
Exactly, man.
Again, long dates will be.
Direct and speedy trial.
The accused was intercepted with
49 bottles of
accused was intercepted না ওখানে বসে লিখলে আমার কোনো অসুবিধা নেই so long as it goes down correctly কোনো অসুবিধা নেই 49 the accused was intercepted with 49 bottles of codeine mixture তাই তো and is in custody for over 500 days. The trial has not yet commenced, though the charges have been framed. The next date for trial is fixed on 5th of February.
22nd, 23rd, and 26th of February.
22nd, 23rd, and 26th February 2024. There are in total 11 witnesses.
8 charge sheeted.
8 witnesses. Post up. The trial, therefore, is likely to take a considerable period of time. there is no requirement of the petitioner being detained for custodial interrogation at this stage. The likelihood of the petitioner influencing the trial is also minimum. The quantity of contraband consumed is of small quantity. The contraband recovered is also of small quantity.
It is commercial quantity.
Commercial quantity, but small. ওইটাকে করে দিন, ও চাইছে। হ্যাঁ, ঠিক আছে, তাহলে কি বললাম ওটাকে বলুন তো। না, ওটা কেটে দিন তাহলে, ঠিক আছে। Considering these facts and circumstances, we are inclined to grant the petitioner bail on the following conditions. যে conditions গুলো দিয়েছি, কন্ডিশন গুলো দেওয়া আছে, একটা অর্ডারে দিয়ে রেখেছি, ঠিক আছে। ওই 10,000 দুটো, একটা লোকাল, ইয়ের সাথে আইসি, ওসি আইসির সঙ্গে দেখা করবে, উইল নট লিভ the local police jurisdiction without prior intimation. Or cooperate with the trial and shall be available before the court as and when required.
I'm opposing the prayer for bail. Lordship, kindly add one line.
Yes.
I'm opposing prayer for.
আচ্ছা, ওখানে একটা জায়গায়, হ্যাঁ হ্যাঁ হ্যাঁ,
to the satisfaction
vehemently satisfaction of
learned special judge witness. And my lord, one indulgence, my lord has recorded as 8 witnesses, charge sheet witness, rather it is 7 witnesses, my lord.
7 witnesses.
Special judge, let me please first court trial. First court trial.
স্টেটের হয়ে লিখবেন, নহলে অরিজিৎ খেপে যাবে, বলবেন ভেহিমেন্টলি অপোজেস দি।
My lord, I am for the petitioner, my lord. My lord, very unfortunate, my lord. 5 years and 5 months I am in custody. 2 persons were arrested. 1 person is on bail. I will not make any submission, my lord, further submission.
For obvious reason, he will not make any submission because the person who has been granted bail, it is statutory bail, my lord. Charge sheet was, yes, charge sheet was not submitted. That is why, my lord, kindly come to your lordship's brief.
On the same day to your
Please, let me submit, please. My lord, kindly come to, he has not paginated, my lord, order dated 8/7/21 of the learned trial court. Pagination is not there, my lord.
As he did not apply, that is why he did not get bail. As he did not apply.
8/7/21. Order of the learned trial court. Have you got it, my lord? My lord, this is
পেয়েছি।
my lord, may I read out, my lord?
ওটাকে সার্টিফাইড কপি গুলো প্যাজিনেট করে না কেন, যদি দরকার হয় ফেরত নিয়ে নেবে বলে।
My lord, may I read out, my lord? My lord, last 3 lines. There is doubt regarding it. The sentence starts, there is doubt regarding. Have you lordships got it, my lord?
Yes.
There is doubt regarding actual date submission of charge sheet. Due to such doubt, I am inclined to give a benefit of doubt to the accused, hence prayer for bail is allowed. Before that, my lord, it was submitted regarding charge sheet, it is stated it was submitted on 26/11/2018, but it was incorporated in the sheet that it was on 10/1/2009. For this reason, my lord,
partnership business, one partner is out.
my lord, one partner, yes, your lordships is correct, my lord. My lord, kindly see the next order, my lord. Kindly see the next order passed by the same court.
Yes, when was the prayer last rejected by
Yes, that is, my lord.
by this court? When was
My lord, it is not paginated, my lord. So, my lord, this is order dated 5/8/2023. Same code. 5/8/2023. No. The learned trial court. My lord, last three pages.
It's my first application.
Third pages, my lord. From the third pages.
5 years and 5 months I am in custody. 5 years, 5 months.
Third pages from the end. Order dated 5/8/2023. Same court passed the order. At both sides, it appears that commercial quantity of contraband has been seized from the possession of the accused. One witness has been examined. My lord, trial is already in progress.
Yes, one witness is examined. Okay.
Yes.
It's pending from 2018.
My lord, kindly see, my lord, the charge has been framed and my lord, evidence was started.
Take down. The petitioner is
And next date is 30th November.
petitioner is in custody for over 5 years after having been intercepted with contraband articles along with how many co-accused?
One.
My lord,
2%.
2 persons were arrested.
Along with another co-accused. The co-accused have been granted bail.
My lord, that is statutory bail. Kindly, my lord.
Granted bail on 8th July 2021. The petitioner therefore prays for being enlarged on bail. On behalf of state, it is submitted that the co-accused was granted statutory bail. The grant of statutory bail does not ipso facto entitles the petitioner, being the other co-accused, to obtain a bail. Moreover, the same court which granted bail to the co-accused, statutory bail to the co-accused, have rejected the petitioner's bail application as late as 5th August 2023.
My lord.
Full stop. State their oppose করেছে বলেছে কি? The state therefore opposes the prayer for bail. Full stop. After hearing the parties and considering the materials of record, we find that the petitioner is in custody for more than 5 years. It is correct that statutory bail does not entail grant of bail as a matter of statutory bail to a co-accused.
It is correct that statutory bail to a co-accused does not
entail grant of automatic bail to the other accused. The trial has commenced and one witness has already been examined. At this stage, we do not find any requirement of detention of the petitioner for custodial interrogation. Since the trial has already commenced, there is also a minimum likelihood of a trial have already commenced and a co-accused is already on bail, even though statutory bail, then the likelihood of the trial being influenced on the petitioner being enlarged on bail is also minimum. Considering these aspects, we are inclined to grant bail to the petitioner on the following terms. So, je gulo thake ta
ACM Barak.
As yours.
ACM Barak. I love Leston.
হ্যাঁ 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 সবেতেই থাকবে ওরা কোথায় পালিয়ে যাবে
এই ACM Barak.
আর মুশকিলটা হচ্ছে বেশিরভাগ আছে ভেতরে মেশানো আছে তো জলপাইগুড়ি ও বর্ডার ডিস্ট্রিক্টে সব পালিয়ে চলে যাবে কত কত ডাকলে হ্যাঁ হ্যাঁ কত ডাকলে 15টা ডেকে
My lord, I am for the petitioner. My lord, I am in custody for 372 days. There is a 21 kg and 205 gram gaja from 3 persons. One of the co-accused granted anticipated bail by this honorable court. Charge is submitted, charge framed. My lord, no one has been examined till today.
Yes.
My lord, from 2 persons, my lord, 21 kg, 255 grams gaja was recovered, my lord. One of them is this petitioner, my lord, and the person who has granted bail, my lord, nothing has been recovered from him, my lord.
Yes.
The person who has been granted anticipatory bail, my lord, nothing has been recovered from that petitioner, from that person, my lord. That's why Miss Sabri, next determined fixed on, my lord, 18th January 2024. And my lord,
very well. Take
the
down.
case has been started only on, my lord, 2nd November of 2022, my lord.
The petitioner
Is in custody, my lord.
Petitioner submits that he is in custody
371 days
for 371 days and a co-accused has been granted anticipatory bail, but we find that no recovery was made from the co-accused. The petitioner is the principal accused. In the charge sheet, though has been framed. Charge sheet has been framed.
Yes, my lord. Yes, my lord.
And the
charge framed.
Charge sheet has been the charges have been framed
19 September 2023,
and the trial is fixed on.
My lord, there is 12 witnesses, but no one has been examined.
My lord, 18th January 2024.
18th January 2024. We therefore are not inclined to enlarge the petitioner on bail at this stage. We only direct the trial to be concluded as expeditiously as possible.
I'm ready.
The application for bail is accordingly rejected. We'll come back at 2 o'clock from 2 to up to 3 o'clock. We'll take the bail matters. Thereafter, we shall take the other matters.
My lord has taken few NDPS matters. You will also kindly take up the others matter from PM, my lord, from 55 on. Few NDPS have been taken.
Or some NDPS matters are there only.
See, if we do not go serially, then others will say that the queue has been jumped. Let us go proceed serially.
My lord, before rising, my lord, may I?
And
my lord, I have taken leave of the my lord on that matter. My lord, now the Hon'ble Municipal Corporation person has gone, my lord, to demolish. My lord, can it be at 2 p.m. My lord?
And my lord, sorry for. My lord,
92. Let us see what can be done.
the last matter, bail matters. No problem.
Can I travel your lordship? 250.
50. Let us see from 3
No, my
o'clock.
lord, only she will not do because the order is such. The entire state is dried up of kerosene.
Your junior had mentioned it.
Yes. That's why I came to disturb your lordship here. But only this criminal, Mr. Ganguly.
No, that's you won't be able to go to your flat.
That I will see.
Since the year 1910-2019, we are in custody with an allegation for keeping 3.2 kg of codeine mixture. And till to date, not a single witness was examined. This is the position.
This is the last order passed by this. Already has annexed.
I have managed matter that is on my lord 23/2023.
Can come to the last paragraph where my lord, time was also framed 1 year. So my lord, that 1 year is yet not completed. There are a few months left. So
I am stating, my lord.
and my lord, charge has been framed. Date for evidences have also been fixed. So my
In
lord,
2024.
my lord,
In 2024.
no my lord, in 2023 on.
My lord, Ford schedule was fixed. Not a single witness has turned up.
Since
Just a minute.
We are aged about 24, 25 years.
Let
4
him
years, my
come
lord.
back
4
after-
years.
Just. What was the what were the dates fixed between this 20th March
I have to
2020?
get that status report, but as
My lord,
of now,
I am saying, my lord.
my lord,
Just a minute.
I am conducting the
If you-
trial. I am conducting the trial. That is why I am stating, my lord.
If both of you speak together, it
No,
will not
no,
be
my lord.
possible.
If she
Yes.
submits, then I will not
my
submit.
lord, my lord, today we've got only the memo of evidence where, my lord, from where we come to know that the next two dates are 21st of December and 22nd of December. But prior to what happened and all these dates, if your lordship,
Yes. I am stating, my lord,
then
3
I
schedule.
need to get a
I am stating, my lord. 3 schedule was fixed. Not a single.
Order sheets?
My lord, my lord, order sheet is not here, my lord. I am stating, my lord. Kindly see, my lord.
Let him come back with
No, no, my lord.
come back with
As my lord, 4 years and 2 months, we are in custody, my lord. That is why, my lord, I am stating.
The question of 4 year or 40 years is not the issue in NDPS.
My lord, yeah.
Because of the 37, unless you can show that the provisions of 37 is whittled down, you cannot automatically ask for a bail.
My lord, it is
The difficulty is that which she points out.
My lord, it is no, my lord, it is truly, it is true that 37 is barred, but it is equally true, my lord. We cannot, my lord, behind the conduct kept the accused persons behind the bar. My lord, kindly have a look into this judgment, my lord, recently passed by the Honorable
Judgment
Supreme
will
Court.
do later. Let us go by the facts.
My lord, here is no independent
Since
witness.
when you are practicing bail matters with judgments, let
Well,
us come to the bare facts.
In respect of judgment,
It's
bail
a
matter.
discretion.
In respect
It's
of
a
bail-
discretion.
No doubt, my lord, it's a
The
discretion.
Supreme Court grants the framework under which you can grant bail.
No, my lord, here is
But
specifically
in
stated,
each
my lord.
fact, in each case, the facts are different.
No, that's right, my lord.
So
This
why
is
why are you showing judgment?
this case is well matching with this case. This case is well
I
matching
have
with
asked you two things. From 20th March 2023, when the last application was rejected, the last paragraph says that the trial should be expedited and should be concluded within 1 year.
Yes.
Now it was your responsibility to state in the petition.
I have stated in my petition. Kindly see.
What have you stated? Where are the supporting?
Yes, ma'am.
that
I have
is
stated,
it
ma'am.
was-
I am stated. Your petitioner state in the paragraph number 2, my lord.
Yes.
Your petitioner state that after rejection of the bail application passed by this honorable court, a serial was fixed on 11/4/2023, 12/4/2023, and 17/4/2023, but no witnesses turned up for which your petitioners are in custody for such and such period. Your petitioner states that, my lord, on 8/10/2019, that is thereafter the case was, my lord, made out. So, my lord, serial 3 dates were fixed, no witnesses stand up. I have categorically
This is
stated.
your statement. Where is the supporting document? Where is the order
Well,
sheet?
as the court is, my lord, closed, my lord, as the court is closed, my lord, I could not collect the certified copy. But my lord, kindly.
See, this has taken place on 17th of April.
Yes, thereafter, my lord, 2 dates were fixed, but no witnesses stand up.
So was the last order.
Kindly see, my lord.
Last order of
My lord, their memo, my lord, kindly see their memo, my lord. Their memo, kindly see.
Just a minute. কোন কথা আছে? Last কথা.
My lord, as a law officer, sorry, my lord, sorry, my lord.
আরো আগে Do you have any order copy after 11th of April?
My lord, right now, I am not, my lord.
Go before the regular bench. If you can bring it, we can put it, place it tomorrow.
Yes, my lord.
If you can get the order copy.
My lord, kindly make it pass over 10 minutes. I am showing, my lord. I am taking, my lord. Kindly 10 to 15 minutes, my lord. Kindly pass over. I am giving, my lord. My lord.
All right. Item number 7. No, well, in these two matters, 17 and 18. No, you must have that.
But you are there.
No, my lord, notice has been served, but my lord, this matter is the NCB is the respondent. Main respondent is the NCB. And my lord, most probably Bidus Roy is appearing for the state.
Yes, don't get involved into dialogues. Let us.
My lord, and for the petition, my lord, in this matter, I have 3 submissions. First thing, my lord, the first thing is that the present petitioner is in custody for 648 days, and my lord, only other than framing of charge, no witness have been examined. My lord, considering the detention, my lord, I'm showing showing an order.
Co-accused is on bail.
No, my lord.
What
My lord, this order was passed by the regular bench, considering the detention and also considering the section 37, bail was granted on the ground of detention, my lord.
Paragraph 5, you have stated.
My lord.
What have you stated in paragraph 5? এটা হচ্ছে অন্য একটা মামলা কাকে বেল গ্রান্ট করা
My lord, that instruction was wrong, my lord. Subsequently, I have gathered that all are in custody.
কিন্তু আলাদা কোনো না মামলা
It's a detention ground. And my lord,
just a minute কোন প্যারাগ্রাফটা বলছেন 5 The petitioner was brought under arrest only on this ground we are rejecting your application.
my lord.
Why incorrect statement? Nothing doing.
My lord, I will correct that. My lord, that was.
Who will correct it? A statement made on oath, who is going to correct it? In paragraph 5.
Then, my lord, I am not pressing this application.
বাবা এত ডেকে নট প্রেসিং
ওটা অন্য একটা অর্ডার ও লিখেছে ভুল ও বলে দিল কো অ্যাকিউজড দিচ্ছে অন্য একটা 1057 অর্ডারটা দিচ্ছে যে অর্ডারটাতে বাক্সি সাহেবের ডিভিশন বেঞ্চ
My
এরকম
lord,
একটা
I am not saying that this is the co-accused. I am not on that. My lord, I am saying that.
We have understood. I am not that duffer. Your statement would in similar situation a coordinate bench has granted this bail. Instead of that, you have stated a co-accused has been granted bail. This is a material misstatement. Material misstatement. You are asking for a discretionary relief and you don't correctly state the facts. On the prayer of the petitioner, the application is dismissed as withdrawn. With না এটাকে উপরে তো ক্ষতি করে লাভ তো নেই কি বললাম না since there is an incorrect statement in paragraph 5 of the bail application, the petitioner intends to withdraw the same. The application is therefore dismissed as not pressed.
My lord, may I get a liberty to file afresh, my lord.
In bail, there is no liberty required. It is not a civil proceeding.
My lord, I am for the petition. My lord, Miraj. My lord, on 5th March 2023, at about 5 hours of the morning, 2 bikes were chased by the BSF personnel. My lord, 6 passengers were there, riders were there in the said bikes. My lord, on their chasing, it has been stated that 4 persons fled away, but 2 persons, that is these petitioners, could be apprehended by the BSF on 5th March 2023. At about 11 hours on 5th March 2023, that is after about 6 hours, NCB was informed that these two persons could be apprehended who were trying to flee away and from their possession, and they admitted their guilt that they were transporting 68 kgs of gaja. My lord, apprehension was, I am in custody for 250 days. Till date, charges have not been framed. My lord, 7th of October, if your lordship kindly comes to the order dated 7th of October, date was fixed for framing of charge. The special PP was absent. Charges could not be framed. My lord, it was a lack on the part of the prosecution. And my lord, the seizure was made by the BSF at 5 hours of the morning. After 6 hours,
Really, what has happened about the rest 4?
Money.
What has happened about the rest 4? You are still chasing them.
My lord, we will, my lord, charges. We have already filed our charge sheet.
My question
they
is,
have not been charge sheeted.
If his statement is correct,
My lord, it is from the complaint and they have not been charge sheeted.
I am asking him a question. If his statement is correct, 6 persons were in 2 motorcycle. Now 2 have been apprehended. Other 4 have escaped. When did the incident take place?
On 5th March 2023 at 5
March
hours.
2023, this incident took place.
Now, what have you done in respect of the 4 others?
My lord, we have filed our charge sheet, my lord.
Only against 2.
We have filed charge sheet against 2. My lord will kindly see this diary, my lord. My lord, we have filed charge sheet. He has the ganja was recovered from these 2 people.
Ganja was recovered.
My lord.
Very well. Now, what have you done?
My lord, the entire case diary is there, my lord.
এটা একটু মাইলটকে দিয়ে দেবেন এটা একটু মাইলটকে দিয়ে দেবেন My lord, this is the first paragraph of the complaint. Lordship sees.
কোন গাঁও বাংলাদেশ চলে গেছে আর 4 কে আর পাবে না take down
My lord, charge sheet.
After hearing the parties and considering the that 68 kgs
of
gaja has been recovered from the petitioners. This is one petitioner or 2 from the petitioners.
And rest 4, my lord, have not been charged.
4 is in Bangladesh.
My lord, not been charge sheeted, and my lord, these persons were apprehended from the road. My lord, they were not found to be carrying the ganja. My lord, I do not want to interrupt your lordship. Lordship, kindly, I pray, my lord, I tender my apology. My lord, they were apprehended from road, and after 5 hours, NCB was informed. My lord, the liability of, my lord, whether these petitioners could be held responsible for the 68 kgs gaja in 2 motorbikes.
That will be in the trial.
My lord, if father, my lord, in trial, my lord, whether special PP was not present at the time or on the date of framing of charge.
1 day.
My lord, in custody for 250 days. My lord, your lordship, on other occasions, my lord, my lord, we are learning by sitting at the feet of your lordship. My lord, 250 days, and my lord, 6 persons were chased.
Don't put us above Shohid Minar. If we fall,
my lord, it is all.
We will not realize when we die.
My lord, it is always a privilege to address your lordships. My lord, 6 persons were chased, my lord, and this.
Take down. 68 কেজি গাঁজা ধরে তারপর বলছে বেল চাই।
My lord, 6 persons, 68.
After hearing the and considering that 68 kg of ganja.
68 kgs.
kgs of ganja has been recovered from the petitioners, and that the charge sheet has
been filed with it.
been filed.
Complaint has been filed.
That is known as, in this case, it is known as complaint, my lord, but it is akin to charge.
It is akin to charge sheet.
It's,
called
but it has been under the act, my lord, it is known as final complaint.
It's final complaint.
Final complaint.
Final complaint has been filed. ঠিক আছে? A final complaint has been filed. The case also reveals that out of the 6,
these people, these two petitioners have been charge sheeted. Means
out of the 6
না 6 জনের নামে চার্জশিট হয়নি
না আমি তো বলছি
riders in the 2 motorcycle, না এটাকে একটু করে দাও, ক্লিয়ার করো, ঠিক আছে, এটা কেটে দাও, ওই করে দাও। the petitioners say that the case of the prosecution is that the BSF, or Border Security Force, BSF in short, BSF patrol team chased 2 motorcycle wherein 6 persons were there. The petitioners were apprehended, but the other 4 persons fled. First. Next, the recovery from the petitioners is 68 kg of ganja. First. The final report has been filed against the petitioners.
And, my lord, may I interrupt one thing? See, recovery was from those bikes in the gunny bags.
ওটাকে ওর কথা শুনে আরো বলে দাও, তাহলে প্রসিকিউশনের কেস হচ্ছে কি বললাম, according to the prosecution, the petitioner says that according to the prosecution, the recovery of 68 kg of ganja is from the 2 motorcycle, but not from the petitioner. However, the petitioners do not dispute that they were not riding the motorcycle.
Yes, my lord, I said that they were apprehended from the road. My lord, it is mentioned in paragraph number 1. My lord, in paragraph 1, if your lordship sees, my lord,
apprehended from the road.
They were apprehended from the road, my lord. My lord, now I leave it to your lordships.
You wanted more material. This will prejudice your trial. Now you say apprehended from the road.
My lord, these are interlocutory orders, my lord. Yes. This never, my lord, observations made in bail orders are never taken in trial.
Unfortunate part is that I may have not done criminal trials, but civil trials I can vouch for.
My lord,
I had the experience of doing so.
My lord,
it fastens some liability. ঠিক আছে, এসো। এতে কি বললাম? According to the petitioner? No, from the motorcycle, and they were apprehended from the road. The dispute remains that whether the petitioners were in the motorcycle or had been apprehended from the road. This issue can be gone into in the trial. After considering the materials on record and the fact that the petitioners are in custody for 210 days.
251 days.
251 days. We are not inclined to enlarge the petitioners on bail at this stage. The application for bail is accordingly.
I'm indebted.
Grateful. Well, since morning 4-0 this side. Well, hoping to come with a
Then what
better
will
case.
this is the first which I scored, Willard. For in the morning, one writ petition was withdrawn, another bail application was withdrawn, so mine was also.
Well, at mine is 4-0. Grateful to that.
Murder for the petitioner. This is my renewal application. This is my renewal application. 70 bottles of cough syrup has been recovered from the petitioner.
What is the change in situation?
My lord, since the last rejection, only charge has been framed.
When was the last rejection?
My lord, January 2023. Page 10 of my application. I have annexed, my lord. Page 10 of my
Next date
application.
of evidence.
Since then, only
17,
charge.
18, 10, 12, 12. Already fixed date for evidence.
1710.
17, 10, 23 was.
1710.
Where is next 12, 12, 12, 23.
Anything has happened on those 2 days?
Well, it is that during the vacation, I cannot get the report.
As per, I have annexed all order, but on those
Commercial
days, my lord,
quantity after all.
no, it is a
Custody for how many days?
1 year, 7 months.
Only 1 year, 7
1
months.
year, 7
only loss. Commercial quantity.
70 bottles fenced.
37 is the bar loss you have.
Charge sheet submitted to
Charge sheet submitted on 11/1/23. Just. So my next date has been fixed already. Can only kind of the rejected on merit lawsuit, last occasion lawsuit.
On the ground of chemical report. Yes, chemical report.
Chemical already filed. Chemical report also filed. Charge sheet on 11/1/2003. Next evidence date on 17/18/10. Next date 12/12.
Take down.
So start page.
The last bail application made by the petitioner was turned down on
20th January 2023.
On 20th January
23.
2023. After hearing the parties and considering the materials on record, we do not notice any change in circumstances between the last rejection and till date. The charges have been framed. The date for trial was fixed. 2 dates for trial was fixed in October 2023, and
next date.
The next date is on
12/12/12/23.
12/12/2023. Full stop. Considering the recovery of commercial quantity,
70 bottles of fencing.
commercial
100 million. 7 liters.
7
7
liters.
commercial quantity.
17 to actual.
7 bottles into 100. That is 7 liters commercial quantity. 100 Codeine mixture.
7 liters of codeine mixture. We are not inclined to grant bail to the petitioner at this
My lord,
stage.
the
The bill
recovery was
application is
70
according to
bottles of fensidyl. Commercial
the
Expedient
trial
chain,
which has commenced
expedient chain.
shall be concluded as expeditiously as possible. And the petitioner shall be entitled to apply for bail if there is any change in situation or there is delay in holding the trial for reasons not attributable to the petition.
ঠিক আছে অফলাইন একটু অ্যাডভান্টেজ দিকে চলে যাচ্ছে কেস ডায়েরি ও কেস ডায়েরি দিই ও দিলে
আমার কাছে
My lord, item 20, I am not pressing this application.
Yes?
My lord, I am not pressing this application. As per instruction, I am not pressing this application.
So, the petitioner does not want to press the application, the same is dismissed as withdrawn.
My lord, my application.
My lord, as on today, this petitioner is in custody for about 2 years. My lord, altogether, nearly about 3,000 bottles of cough syrups were recovered from his premises. My lord, he claims the original accused, he was a tenant under him in that premises. Now, my lord, I am renewing my prayer for bail. Only thing, my lord, the earlier bench, after my rejection, granted bail to one of the accused, who is principal. My lord, I have annexed the order. My lord, kindly comes to page 30. Annexed a P4 on my application. My lord, may I take your lordship to the third paragraph? We have considered the third paragraph, which starts with. Now, my lord, kindly see the third paragraph, where statement under 67 was considered. My lord, my lord, ওর সঙ্গে তো যাকে তার সঙ্গে টেলিফোনিক ডিসকাশন my lord, in that event, may I just try my luck before the regular bench once? No, my lord, why I tell you, lord, my lord, since the regular bench already considered one of the application of co-accused, may I, if your lordship so desires, I will, my lord, I have to comply with each and every order. May I just try my luck? The co-accused recovery did not take place from the co-accused. He was present. Atul Jaswal was present. Only telephonic conversations between the co-accused, between you and the co-accused. Nothing else. No, my lord, may I take your lordship to the complaint once? The complaint says this Atul Jaswal and the present petitioner, they both were there because Atul Jaswal, he opened the door. That is a matter of trial. So that is there in the complaint of the NCB. My lord, may I just try my luck before the regular bench once? My lord, in that event, well, may I just try? After hearing for 10 minutes? No, my lord. Only I have just mentioned for 2 minutes, my lord. Cholo. My lord, my junior is insisting if he can try his luck with the regular bench. Let it go. On the prayer of the petitioner, let this matter be placed before the regular bench, subject to its convenience. Thank you.
My lord, I cannot present তোমার কিছু My lord, for the petitioner. My lord, I am in custody for more than 1 year, 11 months. 2,500 bottles of penicillin has been recovered.
2,500 bottles?
Yes. My lord, till date only charge has been framed. Total 7 witnesses proposed to be examined, and till date not a single witness has been examined.
When was the last rejection?
My lord, this is the first time, first application.
But if your lordship kindly sees the order sheet which has been annexed, in the order sheet it is mentioned that an earlier application was made before this honorable court and the application was rejected.
That is the reason I asked him. That is the reason I asked him. I have seen that. After hearing, this is an application for bail. After hearing the parties and considering the materials on record, along with the commercial quantity of contraband recovered from the petitioner, and recovered from the petitioner, along with the provisions of section 34 of the NDPS Act, we are not inclined to grant bail to the petitioner at this stage. The application for is accordingly rejected.
Grateful to your lordship.
My lord, I am for the petitioner.
Regular bench. No?
Praying for regular bills. My lord, praying for regular bills.
Don't want to say, don't want to take the chance of 6-0.
Fifth.
5-0. On the prayer of the petitioner, the matter is placed before the regular bench subject to its conclusions. May be placed before the regular bench subject to its. না আরেকটু জানো কত পেলাম আমরা
My lord, I am for the petitioner.
Regular bench.
Regular bench.
No, what do you want? Regular bench.
My lord, I am otherwise ready. My lord, the petitioner is in custody for nearly 2 years. Other co-accused persons have been granted bail by this honorable court. Nothing was recovered from the possession of the petitioners. My lord, the vehicle was said to be of the petitioner and the other persons.
Yes.
And page 43 is the order of grant of bail to the co-accused person who has also been granted bail for detention. My lord, page 43. Vehicle was of that of the petitioner. He was not present at the time of seizure.
When the motorcycle was seized, he
Truck.
was not present.
No,
Truck
no.
was, he's the owner of the
vehicle. It was said, but order dated 17/3/2021 speaks that the said truck was taken on hire. By order dated 16th March 2021 speaks that the truck was taken on hire by one Messrs. Karnataka roadways. My lord, thereafter the seizure was in the year of 2020. I was arrested in 2022. I am in custody for about 2 years.
In civil
Trial has not been.
In civil consequence, vicarious liability.
No. My lord, other co-accused persons from whom also nothing was seized and was, my lord, said to be conspirator has been granted bail considering their period of detention.
Yes, page
Page 43. Page 43. 43.
Page 43, yes.
And page 41 is another co-accused. And they were granted bail only in October 2023.
Mr. Trivedi.
My lord, may I?
2 years, my lord.
May I, my lord? My lord, what has happened is 2 people were apprehended. The truck was there, my lord. Here, my lord, in the truck, there was certain Asian paint materials which was booked. But the accused, the petitioner herein is the owner of the truck, and on his instruction, statements were recorded under section 67 by the co-accused, who is the driver as well as the helper. And he said that 15,000 bottles of Fencidril were loaded onto a truck in the garb of the other goods which were there to be transported from Uttar Pradesh to West Bengal at Noihati. Now, my lord, when these people were apprehended, they gave their statements and we recovered. Subsequently, thereto, we sent summons to this petitioner. He did not come and he was absconding. Once he was absconding, we went and by burning a lot of midnight oil and with a lot of oil, we could arrest him. After he was apprehended, then his bail was moved and it was rejected by this one. Now the situation is such that charge sheet of the final report has been filed. Witness action has begun. Now, my lord, there are only 10 witnesses. Now, my lord, if my lord, what I am humbly submitting and praying, subject to my lord's discretion, my lord, if my lord, a time frame is given to a trial judge to complete the witness action, my lord, that will be better, because, my lord, what he is championing for the cause, my lord, that
the old Hindi cinema version does not appeal to us. Incidentally, is not that article which will travel from Uttar Pradesh to Bengal. So, apart from the driver, are there any other witnesses who has supported the prosecution?
My lord, 2 of them, my lord, my lord, co-accused are there, my lord. There are other witnesses also. My lord, the case diary is with us, my lord. There are also other witnesses, my lord.
Regarding
Yes, my lord.
involvement of this petitioners about the crime. So, are there any other witnesses?
No, my lord, there cannot be any other witness. My respectful submission, why I am trying to impress upon my lord, because the driver and the helper, they are the people with whom this gentleman has communicated. He has no reason under the sun to communicate with anybody else, because those are the people who had been entrusted with the responsibility of picking up these bottles and yes, my lord, now to putting it in that truck. And, my lord, my question I'm asking to myself, my lord, with deepest of respect, my lord, when this gentleman was asked to appear before us, he was not coming. He was absconding. Now, my lord, after absconding, if you are the owner of the truck and you have, my lord,
and that was the COVID period, I think, 2020.
Yes.
My lord, what I'm humbly submitting and praying before my lord will kindly see. There is a specific bar, my lord, knows under section 37, my lord. Now, my lord, in my respectful submission, my lord,
much water has flown through the Ganges and Jamuna.
my lord, I bow down. I bow down. My lord, this was just a garnishing on the cake which I was trying to put.
At least to my knowledge, 2002 or 3, CHN reported judgment, which presided over by Justice Devi Prasad Sengupta.
My lord.
Which clearly says that after the 2001 amendment, the 34 provisions are to be read as directory, not mandatory.
My lord, that may I submit, my lord? My lord, that what in spite of that, my lord, it was a garnishing on the cake from my part, my lord. That is not the only point which I am relying upon. At the very outset, my lord, 2 points I had said, my lord, that he is the person, my lord, who was instrumental in, and the person who is the main accused, my lord. It goes without saying, he always tried to put a facade.
Yes, which page is the
41 and 43.
Which page is the petition filed by the petitioner for the release of his vehicle?
My lord?
The petitioner has filed a petition for the release of the vehicle, which you have annexed.
Yes, petitioner did not.
Asian Paint filed.
16,
Definitely, the petitioner has filed the.
no, 16/3/2021.
Please let me tell me the page
Order
number.
date 16, my lord, this is page, certified copy, did not paginate.
No, in this petition.
16/3/2021.
Yes,
My lord is looking at the order dated 16/3/21. 16/3/21.
13/2/2020 petition filed by petitioner Damandeep Singh.
Yes,
Praying
yes.
for return of the vehicle.
Yes.
It's not that the petitioner is all along absconding. At the initial stage, he came for release of the vehicle, and
yes,
you know that subsequent.
My lord, filing of the, in my respectful submission, Millard, in my respectful submission, he may have filed, Millard, but he was not cooperating with my lord.
Probably we are not impressed with the dictation.
Yes,
My lord,
learned advocate for the petitioner and learned advocate for the opposite party are present.
no, then
Yes, how long you are in custody?
My lord, 1 year, 10 months. Since 4th April 2022.
Okay,
41/43.
his bail up to be true.
opposite party.
My lord, his bail application was rejected by this honorable court.
After offending page.
My lord will kindly see page 48, my lord, order passed by this honorable court of my lord's brief, my lord, the petition itself. Page 48, my lord.
Forty-seven.
48, my lord.
48.
My lord, 47 is order dated July 2022.
48, my lord.
Order of the trial court.
No, my lord. 48 is, my lord, order passed by this honorable court by my lord Justice.
Find here.
My lord.
Okay, just a minute.
November 2022.
My lord, my learned friend will allow me to place my case also.
So 48 I don't find here.
My lord, if you, my lord, that is the brief which has been handed over to me, my lord. That is the order which of rejection and which has been stated by them, my lord, in the petition.
Let me see the first page if there is there or not.
48 হবে না 47 of the paginated, 48 হচ্ছে certified copy.
No, my lord. In our brief, my lord, 48 is the order of this honorable court.
You are fortunate. You are unfortunate.
My lord.
The order must be, or the order,
40 is the order of rejection of this honorable court, where this honorable court's
the order
coordinate division bench has held, the trial has started. My lord, may I hand over, my lord, my copy, my lord? May I hand over, my lord, my copy? Page 48. দিয়ে দিন একটু সাহেব।
একদম প্রথমে দেয়া আছে।
My lord will kindly see. My lord will kindly.
একদম প্রথমে সাথে আছে।
My lord has got it.
24-31.
No, my lord. I apologize, my lord. 24/11/2022, my lord.
Yes, if you have the copy, please.
My lord will see. This is the order passed by this honorable court, my lord.
11/20.
My lord, this order was passed by.
আপাতত co-accused bill পেয়েছি।
Passed by this honorable court, my lord.
The co-accused were granted bail thereafter.
Yes, on October.
My lord, the co-accused are not on the same footing, my lord. They have been because of the CDR details, call record details. My lord will kindly see those orders. My lord will kindly allow me, my lord. My lord, will kindly see page 43, my lord.
Object the grant of bail and relies upon the order dated.
My lord, 11th of, my lord, I'm relying on 24/11/2022, my lord.
Now let us dictate your.
I apologize, my lord, but I'm doing my duty, my lord.
Recording your order and submits that by.
Now
order
let us
dated
do our duty.
24.
Allow us.
2020.
My lord, will kindly not take me amiss.
Was pleased to reject the prayer for bail filed by the petitioner. Upon perusal of the materials on record as submitted by the petitioner, that this petitioner on 30/2020, with 30/20, after the incident, made an application for release of his seized vehicle. It is not disputed that the petitioner is not the owner of the vehicle, and it is neither disputed that there was no recovery from the petitioner. It further appears that in the vehicle in which the contraband was seized was not only carrying the contraband but also carrying some paint materials. And as per order of the learned trial court with regard to return of the said articles, it appeared that these said claims were booked both by the petitioner and by the Karnataka Road Transport Corporation. Considering the materials on record and the orders of bail passed with regard to the logic of problem, period of detention, and upon considering the provision
Law of probability is a very.
Yes, Act, this court is of the opinion, considering the subsequent development pursuant to the order passed by 24/11/2022, the petitioner should be granted an opportunity to remain on bail. Thus, I allow the prayer for bail made by the petitioner.
On the following conditions, conditions for us.
Released on bail with two sureties of rupees 15,000 each, subject to satisfaction.
My lord will kindly record my objections, which I have.
Recorded, yes.
My lord, I apologize, my lord, I could not hear it. My lord.
This is CJM.
CJM Barashat, not 24 persons. Since my lord, NDPS court is closed now.
Pursuant to the release, or condition will be.
চারটে কন্ডিশন
I'm grateful.
আচ্ছা একটা সেন্টেন্সে ওরা দুটো নেগেটিভ গেছে মানে এর কাছ থেকে কোনো রিকভারি হয় সেটা কিছু
I'm grateful, my lord.
Mr. Trivedi, now the matter is over. Have you traveled in bus during the off hours?
Yes, my lord, I have.
You have in private buses.
Yes.
You will find the conductor and the driver, they carry goods to earn their tiffin and other expenses. So this is probably such case. The owner had no business. He is owning a truck. He is getting his hire. Why should he transport 1,500 bottles of Fencidil?
15,000 bottles, my lord.
15,
Therefore, that
what-
is only 1,500 bottles. But my lord, whatever it is, my lord, we are. Well, it is my duty to oppose the bail, my lord, to the best of my ability.
May it please.
I'm grateful.
May it please, Lodge. My lord, this is under the NDPS Act, though, my lord, this is different, my lord. My lord, in this case, the writ court has noticed prima facie that there's been a false implication of the petitioner in the present case and has stayed the entire proceeding. My lord, I shall take your lordship only to 3 orders, my lord, passed by the writ court. My lord, first order is on page 89, my lord, of my petition. My lord, page 89. My lord, with regard to the conduct of the Titagore police station, in respect of how they have falsely implicated the petitioner, my lord, the writ court has made detailed observations. But the first order is on the 30th of August 2023, page 89. My lord, has your lordship got it, my lord?
You want to move this application before us?
But the trial has been stayed, my lord. This case, my lord, the Titagore police station, my lord, has falsely implicated this particular person, my lord, and has made prima facie observations with regard to how and in what manner.
What are you asking for?
My lord, we are paying for bail, my lord. Because the liberty was granted because the trial was stayed and liberty was given to pray for bail, my lord. In terms of that, my lord, I have come up. Now that the trial has been stayed, my lord, There is no point keeping me in custody.
Why before the High Court?
My lord, I've approached the lower court, my lord. The learned sessions court has rejected my bail prayer, which is why I've come up before your lordship. That in a case like this, in spite of communicating these orders, my lord, if your lordship kindly takes the pain to take page 89, my lord, once. Page 89, order dated 30th of August 2023, my lord. But as your lordship got that, my lord. My lord, the entire story has been given here, along with the findings of the court. This writ application was preferred with regard to this false implication and praying for transfer to NCB with regard to how this quantity of codeine was, how this quantity of commercial quantity of this NDPS substance was procured by the police station. But then, with regard to my call details, with regard to everything, it was pointed out that I was in AP Devi Road in their custody from 6 o'clock. And the writ court has made stern observations, my lord, at page 92. Opposition page number page number যেটা অপোজিশন যেটা বলছি সেটা
Yes, what do you say?
My lord, my lord, there are two more orders, my lord, because this is the first order. My lord, the second order is page number 94. Now the police station was directed, the state was directed that you preserve the CCTV footages. Directed. Next page, my lord, page number 94 is the next order. That is order dated 25th of September.
Not produced.
Not produced. And on the last date, my lord, the court was shocked that they could not, they have not preserved it. And my lord, that is why the proceedings were stayed. Liberty was given to prefer bail. I prayed for bail before the learned sessions court. Sessions court denied my bail application.
What is that order? Liberty?
My lord, that is, my lord, I'm telling your lordship, lordship kindly takes up page 115 of my petition. 115. (115) 9th of October 2023 order, my lord. Didi, pure bolchi to. Page 116.
Yes, seen that.
Page 116, my lord, my honorable judge was asked. My lord, one more aspect. Now, for the first time, my lord, during this writ proceedings, the state has now admitted if I can just show one page, page number 101, in their affidavit in opposition filed in the writ court, that yes, they have admitted on that particular date, they have gone to visit me. Page 101 of my petition, in their affidavit in opposition, they have admitted it. Which is why, my lord, these were the consideration. I was myself arguing the matter there, my lord, which is why one of the considerations on which the matter was stayed. So now that the proceedings are stayed, my lord, the scope of section 37 also does not apply, as the entire issue is being looked after by the writ court, my lord. I am in custody. But if I can take your lordships once to page 101. Paragraph number Roman 4, page 101.
ট্রায়ালটা করবে এটা ছিল কি ছিল না তাহলে কিছু অর্ডার কিছু তো করার নেই কনসিডার করতে
They have failed once prior to this. They had previously tried to implicate me in an NDPS case. I was acquitted. That was also considered by the writ court. And this is the second attempt. And similarly, in respect of another case, my lord, where my lord Justice Rompa Sarkar was pleased to also impose a cost of 2 lakhs upon the Titagore police station for this conduct, my lord. And that has also been considered in the writ court's judgment, my lord, with regard to the place of call detail recording, my lord. Though this is the judgment, my lord, I've got it, my lord, 2 copies of it. My lord, please, Justice Rompa Sarkar's judgment, my lord, which has been reflected, my lord, and this is my.
This writ petition is still pending, my lord. We are supposed to file details of this CCTV, my lord. That I have to take instruction whether how much they are ready with. With regard to, my lord, the merit of this case, as to, my lord, the Caesar and everything, my lord, earlier this matter had come up before this coordinate bench, before this Honorable High Court, and, my lord, it was rejected on 25th of.
After that, the writ court orders were passed.
So, my lord, my lord, this is still pending, my lord. We had.
But you can argue that to what extent the writ court can go into these issues. Very well. To what extent the writ court can be substituted for the trial court.
Grateful.
You can argue. But as of now, when there is a prima facie finding by the writ court, and you have not challenged that.
Well, I'm not aware of.
No, not challenged. I'm stating it, my lord, real and normal, not challenged at all.
You have not challenged it. Now, after finding such material, the code below did not even make a whisper about it. This is a classic case of the provisions of appeal, though the appeal does not lie in this sort of cases. Classic case. Take down. The petitioner's bail application, first bail application was rejected on last bail application. Last bail when before this court?
Last bail that was rejected, 25th of July 2023.
2020. After that, the writ court orders were.
Yes. Which page? Which page?
My lord, that is at page number 13, my lord, annexed to P1. 25th of July 2023. It was on a different point, my lord, statutory bail, but subsequently the writ orders were passed on 30th of August.
The petitioners
only one petitioner.
The application for statutory bail by the petitioner was rejected on 25th July 2023. Subsequent thereto, the entire proceedings have been challenged by the writ petition by the petitioner by filing a writ petition being WPA number 4022 of 2023. In the said writ petition,
WPA number 21188 of 2023, page 89.
Yes, 21188 of 2023. In the said writ petition, after making prima facie observations, the learned judge had do you say where is the stay of the trial?
That is at page number 115. That is the third order. No, I'm till 30th of November. That is page. Oh God.
Just a minute.
Page 115, my lord, of my petition.
You have read your brief. We are reading it for the first time.
Page 115 of my petition, my lord.
Just
that is on
after after recording directed preservation of the CCTV footage of the police station on and from 19th November 2022 to 20th November 2022. Directions for filing affidavits were given. Subsequently, the writ court noticed that the CCTV footages as directed were not preserved and as such by an order dated 9th October 2023, the trial was the trial is directed to remain stayed till 30th November 2023, except consideration of application for bail. Full stop. The petitioner thereafter made an application for bail which has been rejected by the learned
special judge, NDPS, my lord, Barakpur.
Well, can you record my objection to it?
It is after page 116, my lord.
by an order dated 18th October 2023. The petitioner, in the present facts and circumstances, is seeking to be enlarged on bail. Full stop. on behalf of Union of India,
Well, as state of West Bengal.
on behalf of the state, the application for bail is vehemently opposed on the ground that the writ petition is pending and the trial has been stayed for a limited period.
My lord, moreover, there are criminal antecedent of this person.
In the event the petitioner is enlarged on bail, there is every likelihood of evidence being tampered and the trial being influenced, particularly keeping in mind the criminal antecedent of the petitioner. After hearing the parties and considering the materials on record,
And my lord, commercial quantity.
commercial quantity is always there.
Because earlier those things were considered and rejected.
কি বললাম?
এই পুলিশ স্টেশন যদি বাস হবে
Materials on record, we find that the entire case of the prosecution has been prima facie doubted by the writ court, following which the orders as aforesaid has been passed. Charges have been framed.
No,
Charges have been
framed. Thereafter, it was.
Evidence is unloaded on 17th of November.
How can it be? It is stayed now. So
So that is
কি বললাম?
charges have.
The charges have been framed and one of the witnesses have been examined.
No, no.
It was fixed on 17th of November, but since it has been stayed till 30th, so now
And the matter was fixed for trial on 17th October,
November, not this month.
17th November 2023, prior to the same being stayed. Full stop. Considering these facts, we find that there is no requirement for detaining the petitioner at this stage for custodial interrogation. Even though the recovery is said to be of commercial quantity, but keeping in mind the doubt which has crept keeping in taking into account taking into account the doubt which has crept in the mind of the writ court, we find that the provisions of section 37 of the NDPS Act gets diluted in the facts of the instant case. The petitioner is enlarged in bail, is enlarged on bail
to the
satisfaction. ওই 10 করে দেবেন দুটো সিওরিটি
special court
to the satisfaction of which কোর্টটা নিয়ে নেবেন
Learned Special Judge Barakpur.
NDPS
Learned Special Judge NDPS.
ACJM
ও এখন তো বন্ধ আছে
ACJM
ACJM Barakpur. I'm deeply grateful. Learned ACGM Barakpur. Well, now the courts are shut, so that.
CJM,
No more criminal activities.
CJM para, ঠিক আছে?
ACGM Barakpur.
Subject to the following condition, ওই চারটে condition দেয়া আছে। আচ্ছা।
Debrief.
Yes? Yes, have you got the order copy?
No, my lord, I got the date, my lord.
মানে 92 maybe ওইটাকে 16টাকে হচ্ছে রেগুলার বেঞ্চে পাঠিয়ে দিন।
Great for month.
No, 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 and what are the get first and thereafter regular, send the regular.
No, no.
My lord, my submission may can be noted down, thereafter, my lord, send the regular.
No, no, no.
As because, my lord,
You have wasted much time, now the others are waiting. You took time to produce the order copy. Have you produced the order copy? No.
No more criminal activities.
ওইটা 92টা দেখে দাও, মেনশন করেছিল।
Great for
This will be the last bail application.
ছোট করে কর।
একদম ছোট ম্যাটার তো দাদা। My lord, petitioner number 1, my lord, he is in custody for 2 years, 5 months and 2 days. And petitioner number 2, he is 2 years, 4 months and 22 days. My lord, this is a case of 302. And my lord, the entire case is based on circumstantial evidence. There is no eyewitness. And my lord, the persons, 3 persons have been granted bail. Out of that, my lord, one Kanchon alias Pratik, my lord, he has been charge sheeted in the supplementary charge sheet, and my lord, arms was recovered from his custody. And he is on bail. And my lord, there is no eyewitness.
Mr. Ganguly, I will not be able to take up this. Nakashipara police station, my native place police station, I will not take it up.
Sir.
I do not know who is where involved. I don't want to get into any controversy.
My lord, my lord.
If I had looked into it, I would have straight away in the morning given you leave to go elsewhere.
কালকে করে দে।
No, my lord. My lord, let it be placed on tomorrow,
Yes,
my lord.
কালকে। হ্যাঁ, not today করে দাও, কালকে let this matter was mentioned for being taken out of turn in view of the urgency. Let the same be placed before the vacation bench on 8/8. 9.
Then, my lord, again, I will have to mention tomorrow, my lord. My lord, let it be top of the list, my lord. Let me get an opportunity to hear out them.
Then it will remain in the list.
My lord, let it appear at the top of the list, because, my lord, again, I will have to take leave. Your lordship was kind enough to allow me and started to solve this matter. Unfortunately, it can, my lord, don't mind. Let it be top of the list, my lord.
That I cannot, because that is the prerogative of the bench. It will be there. This is, I think, this will
Well,
be.
it will not be heard out, my lord. This is.
এটাই বলবি my lord was satisfied.
সেটা তো আবার আমাকে করাতে হবে।
I cannot do that.
As your lordship.
ঠিক আছে, এবার অন্যগুলো ডাকুন। হ্যাঁ, হ্যাঁ, না 250 না, ওই গ্রুপের লিস্টটা ডাকুন। কন্টেম্প কি করে হবে? কার অর্ডারের কন্টেম্প? যে যা পেরেছে লিস্ট করে দিয়েছে। হিবিয়াস কর্পাস শুনবো না। যেগুলো মেনশন করেছে, 3টে না 4টে মেনশন করেছে, ওগুলো আগে নিয়ে নি। একটাও বিশ্বরূপ করলো, আর একটা ওই কেরোসিনের করেছে, আরো 2টো বোধহয় করেছে, ওগুলো আগে। ওটা 4টে আসছে বলছে, অরিজিনাল সাইড ওটা। Those which were mentioned in the morning, let us first call that, then I will try to go serially.
Item number 250. Item 250. Item number 250. Don't look at the size.
Well, I have two preliminary objections. One, that the appellant has not filed any affidavit before the single judge. So some additional 600 pages they are relying upon. They cannot rely anything except the writ petition. One, and two, the state petition as made is not maintainable. I make my submissions after Mr. Basu concludes.
Maintainable নয় কেন বলেছে? উত্তর দিয়ে দিই। I need not look into any document which was in the read court. Can you look that? Or can you see the order improved? 2 pages order. Can you look into? So, memorandum appeal টা দিয়ে ভলিউম টু ভলিউম করে না চলো খেয়ে আসি মিষ্টি মিষ্টি ভালো লাগবে না পানি নাও আগেই দেখুন বসো 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 নিচে বসে নিচে ঠিক আছে পেছনে পেছনে বসো বসে না কাটাকাটি শুরু করি Hello, read that. Apart from the ground that there is lack of any reason for granting an interim order, I have some more points to say on the basis of the writ petition.
Just a minute.
Okay, second November. এটা কোথেকে পেলে ধন্যবাদ
Yes, Mr. Sarkar, first query. Since the respondents were not there, I do not know whether you had served or not.
My affidavit service was on record.
I'm going to say this is not in effect an ex parte order. It was served on me. We failed to appear.
Very well.
And Lordship was in appellate side. If the matter appears in that list, that is sufficient notice.
No.
No, ওসব বললে হবে, but we have served.
As per appellate side rules.
So far as I am aware, I was a part of the larger bench which directed specific service. Justice Somar.
Service was made.
No point. Let us take the bull by the horn. Now, why have you chosen these 5 persons only as respondents?
Well, 5 persons came to my advon record. That's why, my lord, because they are all aggrieved. Whole state, all citizens of West Bengal are aggrieved. Actually, the origin of this writ petition is an earlier order. I hope let my learned friend finish.
46, 47 is not there.
I am not taking this point. If at all necessary in the final hearing, cannot take this point that writ petition are maintainable, because in earlier round this point was taken and court held so writ petition is maintainable.
Because this is pan West Bengal case or whatever may be, it is in the nature of a representative one.
So I am not taking this point. What I am taking the point, the cause of action of this case is the similar cause of action in the earlier writ petition. In the earlier writ petition, apart from the prayer of framing a scheme, an identity murder was prayed for. Since 2022, no interim order was passed. The Honorable Single Judge disposed of the matter. What he has directed? He had directed the state government to frame a scheme, and that too without any specific time limit. Kindly see when the judgment was delivered. If you Lordship kindly look. That is on 12th September 2023. And this judgment the interim order has been passed on 13th October 2023. The person who has obtained the order, he has not come to the court with a contempt application. That the order which has been passed at that instance has not been complied with. A third party who was not there only look into the, my lord, penultimate paragraph of the order, where the court has not passed an order saying till such time the scheme is framed, you cannot do this. What is the resultant effect? But I am the Indian Oil Corporation. This is not, my lord, don't equate with the coal. Coal is my product, of the Coal India's product, in the only mining expenses. This is the oil. The Indian Oil Company has to purchase it from outside by giving foreign currency. So it has a right to fix the price limit, price of sale. Now the direction given by the Honorable Single Judge, while the same Honorable Judge has not directed any order to be passed that till such time scheme is framed, you cannot charge. The same order has been passed in the subsequent deed application. Meaning thereby, I have to sell the product giving loss to the public exchequer. And what is the grievance of the writ petitioner and the other writ petition also? The subsidy. What is subsidy? Purchase price is same. The consumer will get the benefit. I will get the subsidy from the central government. I cannot run in loss. I am an individual, my lord, individual oil company. I cannot sustain loss.
You are a government of India.
Right. But I cannot sustain loss unless
your substantive control, you may be a policy matters the central government.
Right. I have no doubt about that. This court has not directed me to frame a policy. It is directed the central government to frame a policy for the purpose of subsidy. Subsidy, if granted, then I will be getting the benefit from the central government in respect of per individual consumer. Up till now, from 2022, total subsidy has been stopped. Now, there is a policy also. Now this LPG has been promoted for the greener fuel. The selling of kerosene is not, my lord, greener fuel. So this policy of the government is to, my lord, totally stop. At least, my lord, 10 states has stopped it. This is the policy of the central government. So Mr. Trivedi is here, he will apprise, my lord. So under this policy, when the order has been passed to to frame a policy without any clock, that till such time the policy is framed, there should not be any clock on fixation of price. Then why, my lord, I am asking the question to myself. Not a subsequent writ petition. That order which has been not been obtained by the original writ petition, again obtained by him. And that too, another thing is there. He will say, I will add them. The price fixed by 3 oil companies. Only Indian Oil Corporation has been restrained. But both BPCL and others also there. So they are, HPCL, BPCL are also there. They had not been stopped. So there is a class within the class has been framed by this order input. These are the sum and substance of this. Now,
see, Mr. Basu, so far as we understand, the price of the kerosene is fixed.
but can you take the microphone? He is aging. He is hard of hearing now.
Well, I don't deny aging, but I did the latter part.
Now, so far as we are aware, the price of kerosene is fixed by Indian Oil. Whether it is to be sold in open market or
subsidized price
or through PDS system or any scheme. Now, the price, say it is 100 rupees. In open market, available at 100 rupees. If it is available through any scheme or PDS system, it may be available at 80 rupees. The 20 rupees subsidy will be given by the government
to me,
to
the
Indian Oil. To Indian Oil.
Absolutely correct.
This is the policy framework. Now, if you come to the order which records paragraph 46.
Oh, my lord, the earlier one.
Yes, earlier.
Kindly come to 46.
Ah.
This is the only.
Therefore, the instant writ petition is disposed of directing the central government to adopt and take a policy decision for fixing the rate of subsidized.
I am giving emphasis on that.
Subsidized.
Subsidized, yes. If you stop me from fixing my rate, I am also selling in open market. I am also selling in, my lord, through PDS.
So
that entire writ petition is based on the earlier one and this one also based on subsidized kerosene through PDS.
Subsidized rate হচ্ছে scheme frame করতে বলে। হ্যাঁ, ও তো ওপেন মার্কেটেও বেচতে পারছে না।
And 47 also can lead. Yes,
Yes,
we have 47 also.
We have read that. That's
47 also, my lord, is a component which the state government fix it.
Taxes.
Now kindly see 614 of your lordship's brief, which is the subject matter of challenge in writ petition. The volume na nota dite hobe ekটু. It is too bigger. I am big volume. Kindly, Justice Chaudhary, kindly take up 614, which is the subject matter of challenge in the writ petition. Once can you look to the document which is subject matter of challenge, 614. Can you allow me to do it, my lord? Consequent upon
Just
my on October, government of West Bengal fixed the price, ultimate price fixed by government of West Bengal in respect of every state. May I read with my lord?
yes.
Consequent upon revision of ex-depot best price of PDS superior kerosene oil with effect from 1st October 2023, all the supply locations of SKO in West Bengal, next is important. As communicated, 614 my lord.
Second volume is 614.
As communicated by the Deputy General Manager, WBSO Indian Oil Corporation Limited. Joseph খুঁজে পেয়ে দেখ না 614 পিছনে লোক বসে আছে ছুটি লোকেশন সেই জন্যই
Yes.
So this is one of the component. This price fixed by my purchase price, my cost, I add and sent it to state government. Now the other components, these are the components added to by the state government, who is the ultimate authority to fix the price under PDS. Now what is the interim order? Interim order said, I cannot fix the price excepting what has been sent in September. If the market rises, I cannot raise the rise price. How can I supply? I'm asking the question to myself. And if ultimately writ petition does not succeed, if the ultimate consumer gets it, I cannot get back.
The only answer, why were you not there?
Before the writ court.
Where were you not? This is applicable only to you, not other oil companies.
That cannot be. That is another aspect. But here it is not applicable to others. It makes a class within a class. We are at part. HPCL, PPCL and IOC is at part. Yes. What happened? This is the evil of which I always deprecate. This practice of sending notice under email. Notice was sent email. Normally missed it. Not physical copy. So it has gone out of his mind of my learned advocate on record and could not appear.
You are not that savvy, Mr. Nagis. It had appeared as a.
No, he said me that it was email. That's why it gone out of my mind.
It was in.
Sorry to interrupt.
It was in the spam box.
I don't know. I don't give so.
No, Malad. It was served by hand at the office of Indian Oil Corporation.
Oh. Creation of this email. So yes, these are the points, Malad.
Sarkar.
And the reasoning is another thing. 1 minute, not more than 1 minute. Can you see the reasoning?
For interim order.
Can you see the reasoning? Is there any reason excepting quoting the judgment of his lordship, where he has said directed to frame a policy? Nothing else. No reason at all.
Mr. Sarkar.
Lordship, this is the continuation of his lordship's earlier order. So unless friend has already referred that there was an earlier order, unless lordship sees that earlier order, lordship, it will not make clear. Lordship kindly sees 2 paragraphs.
We will look into it. We'll look into it. No difficulty.
Lordship.
But for the purpose of interim measure,
Lordship.
Today we are not hearing it out.
Lordship.
It has to be heard out.
Lordship.
Now, give us one answer.
Lordship.
Is not Indian Oil free to fix its price per liter of kerosene?
No. Because it was held, it has no power. Under the 1993 control order, only central government can. And we came, the earlier portion, also, I also appeared in that matter also. We came up before court because central government was not fixing the price and leaving it to the oil company. They were fixing, Lordship, I showed the chart. Lordship, see the chart. Price of kerosene, which used to be 35, when kerosene was, petrol was 43, petrol was
pegged or capped or fixed for continuous months at 53, the price of kerosene went up to 107 rupees. They were sponsoring petrol at the cost of kerosene, whereas kerosene is a poor man's fuel and petrol is a rich man's fuel.
Benefited by them, Mr. Sarkar.
That's besides the issue. So we came up before court that oil companies have no jurisdiction to fix the price. Under section 2D, law section 6 sees the legal provision. 93 control order though. না যাই হোক বইটাই দাও 635 বইটা আমি দিয়ে দিচ্ছি
Sir, not the ground forward by the order of second.
these were already there. What I mean to say, I'll come to that. Lordship Cabinet sees 501. It is also quoted in the petition, Lordship. 2, section 2, Lordship can see D, declared price. In relation to kerosene sold under the public distribution system means the maximum selling price declared by the central government from time to time with reference to an area and shall include such other charges, rates or duties or taxes prescribed.
Yes, that is not in dispute.
So
how you come to the interim order?
Lordship, Lordship, can I come to the first one
Respondent
paragraph?
number 1
Lordship.
is restrained from determining the price of kerosene oil more than that what was fixed in the month of September 2023.
Why, my lord, why?
The disposal of the instant writ petition.
Lordship has rightly pointed out. The question is why. The answer is in the earlier order. Lordship can take page 498. It starts. 498 volume 2. It starts. IOC fix करें 522 बोल
Presently, the price of the kerosene is not fixed because the oil company.
Page 419.
At page 498 it starts. It's a very elaborate judgment. Lordship come to page 520. I'm sorry, 528, 29, 530. At page 530. Therefore, it is a finding by the court from which no appeal has been preferred. So this remains still the law. Therefore, it is the duty of the central government to fix subsidized price under PDS kerosene scheme 2016. The oil companies cannot fix the price of kerosene in the manner on the basis of import parity pricing. Next, the courts, therefore, this is a finding, and one more finding is there. Pasha, can you give me a minute? That page. I'm sorry. It was state government filed an affidavit in this proceeding saying because of their exorbitant price, the beneficiaries of the government are unable to purchase kerosene. It has gone up so high. State on affidavit on oath submitted that, my lord. That is also stated in the earlier judgment.
What is the price now?
When it came, it was 107 rupees per liter, whereas petrol was say about 75-80 rupees per liter. And today, 67 is the basic price.
By the oil company also.
67.
It is around 100 to 110 rupees. I do not want to share my personal experience. But in my native place, I have a generator which starts with
Kerosene. Oh, petrol then
and
runs on
operates with-
kerosene. Yes, yes, that is to
So
be.
for that, I have to purchase from open market. It is between 100 and 110 rupees.
Loss.
Now, under the PDS system, what is the rate?
Kindly keep your lordship mind the policy of the central government.
Page 528, once more I'll show to your lordship, my lord. Paragraph 40. Paragraph 40 at page 528.
Yes.
1993 control order defines public distribution system as the system of distribution, marketing, or selling of kerosene at declared price through a distribution system approved by the central or state government. Therefore, it is the primary duty of the central government to declare the price of PDS kerosene for distribution. Open market price, oil company can decide as per market conditions. We have no quarrel there. It's not subject matter of challenge in either of the writ petitions. This power cannot be delegated to the oil companies. What central government was doing, central government was shirking his responsibility, leaving on the oil company, and I have annexed my writ petition, Information Right to Information Act, that how the price of kerosene is fixed. In writing, they replied, we are fixing according to international price of jet fuel. And jet fuel has 65% petrol, 35% kerosene. So the price of in America is being charged from the consumers in India. It is clearly profiteering. That is what court restrained.
While using the card, have you ever checked what is the base price of petrol or diesel?
No.
And what are the other additive prices factors?
Gulf War surcharge has been included there. Gulf Wars in our younger days. That surcharge is still there.
What Vivlan says, I'll accept it, but that's not the issue. When the court specifically restrained the oil companies not to fix the price, in spite of that, Lordship has seen that page, my learned friend showed, page 614.
Yes, very well. Who is for the Union of India?
So,
Who is for the
so
state?
this earlier judgment asking that oil companies cannot fix price was passed on 12th of September. So, and there was no time limit by which this is to be followed. The present writ petition are parties in the earlier writ petition, so no contempt could be filed by a stranger. So, my lord, my client was advised to file a fresh writ petition and restrain the oil companies because there is continuing. This is they are committing contempt and openly committing contempt.
Yes, who is for the Union of India?
And in fact, my lord, this interim order has been.
Yes.
My lord, in fact,
where is he?
Other oil companies have implemented this interim order. Only why appellant is not complying, Lordship, I don't know. This is the record. Our copy ache
Big Bull. Big brother. That's
big. He is big brother. Yes, big Lordship. So others, they have implemented the entire. How they are prejudiced? If the consumers, they are ration card holders, they have to take kerosene and at the price declared by central government. Today they say they will incur loss. Is it a ground to violate a court order? And what is their prejudice? If they are lost, they will be compensated by central government and their price will be added in the next month's price. What is the urgency in this application?
Who is for the state?
State has supported me, man. State has on affidavit supported me. The submissions of state are recorded in paragraphs.
Control order has been handed over, my lord. 41C. Can you see?
Yes.
Which one?
That
4(1)(c).
well, he cannot agitate same points again and this was considered and rejected
No,
by
that
the
has
earlier
not been rejected.
provision.
That is not the order of the court. Kindly come to C.
ওইটা
Mr.
উপরে
Chaudhary does not have the control order. C kindly interpret.
আমার control order কোথায় গেল? না না
So it is not the only central government and the oil companies also.
ও এইখানে
সাবসিডাইজটা হচ্ছে ইয়ে পারবে না।
well there is a open market kerosene and there is a PDS kerosene.
পাবলিক পিটিএস এ হচ্ছে পারবে না
Central government.
সেন্ট্রাল গভর্নমেন্ট। ওপেন মার্কেটে ফোর্সি
Of course they will decide that. That is neither here nor there. And this they have not filed an affidavit in opposition. Let the state petition
It ultimately goes to the consumer. It cannot be recovered by anyone.
cannot their ration card holders, they are at the mercy of the government anytime. If any shortfall, it will be added next month.
Everybody is at the mercy.
While Anifana said there is no openly violating the order of the court. There is no direction on me.
Yes,
There is no direction
this
on
is
me.
this is the holding that
Central government is to came with the state
no,
government.
no, it says the oil companies cannot fix the price of kerosene.
That is not the direction. That is my lord, the part of the order. Direction is two paragraphs, 46 and 47.
Is Mr. Trivedi available? The unfortunate part, this matter started, he was there.
So lordship directs and why the state petition is not maintainable, my lord. I made the submission. Let me make that clear, my lord. If your lordship kindly take up the state petition. My lord, I have said that this is not state petition not maintainable. Lordship can take page 34 of the state petition. Page 34. I have to indicate why, my lord.
Mr. Sarkar,
lordship,
at this stage, all these points.
Because you know, it touches the point. It touches the interim order. Lordship, can I page 34? This is the prayer of the state petition. Lordship, take a prayer B. Side by side, prayer 44 of the earlier judgment, which is a mandamus and binding on the appellant. Fixed price of PDS ESCO as per the laid down in PDS Kerosene Domestic LPG Scheme 2002. And court said they cannot fix. So he's, without preferring an appeal, he is trying to set at naught an earlier order.
Take down. Subject matter, the subject matter of challenge in this appeal is an order dated 13th October 2023, passed in WPA 24540 of 2023. Full stop. Although, comma, the appellants did not appear on the day when the impugned order was passed, but it is an admitted position that they were served with the copy of the writ petition. Full stop. in a previous writ petition wherein the writ petitioners were not the parties. An order was passed on
12th September.
495.
498 it starts. Judgment pronounced on 12th September 2020.
ইনে কি বললাম ইনে না আগে যেটা সেন্টেন্স দিয়ে শুরু করলাম being WPA number 9735 of 2022 wherein the present petitioners oblique respondents number 1 to 5 were not parties. An order was passed on 12 September 2023. By the said order, the central government was inter alia directed to frame a policy to fix the price for kerosene oil to be sold through
Public distribution system.
Public distribution system, in short PDS, at a subsidized rate.
There is no subsidy nowadays. Whole subsidy abolished from 2021. So,
Order is there subsidized. You see paragraph 46.
That's the order.
Paragraph 46, subsidized.
Paragraph 44.
subsidy.
16 scheme আলাদা scheme আছে।
That's why state government has got.
It was the now it is the case of the writ petitioners oblique respondents number 1 to 5. No, 1 to 4, sorry. Respondents 1 to 4, not 5. 1 to 4, that despite there being such an order, the Indian Oil Corporation, in short IOCL, the appellant, have enhanced the price of superior kerosene oil with effect from 1st October 2023 by a memorandum dated 3rd October 2023. Under the kerosene bracketed restriction on use and fixation of ceiling price bracket close order 1993 hereinafter referred to as 1993 control order কি বলেছি আন্ডার আন্ডার সেকশন again after Indian oil can sell kerosene oil through PDS system, through PDS at the maximum selling price declared by the central government while হ্যাঁ ওই while না ওটা কেটে দিই পোস্ট which page is the memorandum?
Memorandum of
That challenge.
Oh, 604. 614.
The state government, by a memorandum dated 3rd October 2023, has fixed the price of PDS superior kerosene oil bracket SKO with effect from 1st October 2023. At all supply location of SKO in West Bengal. The said memorandum is at page 614 of the stay application. The
I'm sorry to interrupt, my lord. Lordship says 614, price fixed by state government.
Yes, Khaddasri Bhavan.
Price fixed by Indian Oil, tax calculated by state government.
Ultimate price fixed by state government.
Logical since first sentence, division of price communicated by the general deputy general manager WBSO in annual corporation. So price fixed by in annual corporation, tax fixed by state government, state taxes and commissions, handling charges, all these things.
হ্যাঁ এটা কি ইয়ে ছিল কি
Ultimate price টা fixed by price টা fixed by state government.
At all supply location of SKO is
ওখানে অ্যাড করে দিন consequent upon revision of X depot base price. Full stop দিয়ে the base price is however fixed by IOCL. Full stop. The learned single judge has restrained the respondent number 1 bracket A appellant. Respondent number 1 in the writ petition being the appellant hearing from determining the price of kerosene oil more than that what was fixed in the month of September 2023 till the disposal of the instant writ petition. Till the disposal of the writ petition. Full stop. While passing the said order, the learned single judge relied upon a portion of his order dated 12 September 2023 passed in ওই WPA দেখুন 95 কত একটা আছে হ্যাঁ ঠিক আছে 95 full stop. This is the this restraint order is being assailed at the interim stage of the instant appeal. It is correct that the price of SKO under the PDS system is determined by the central government, while other applicable charges are determined by the state government. The revision of such price, therefore, has to be through the central government. This full stop. This, however, does not preclude the oil companies, in the instant case IOCL, from arriving at a base price for the consideration of the same being revised by the government at the instance of an oil company like IOCL in the instant case. The distribution and the sale and distribution of SKO under PDS is through the state instrumentality. The oil company will at all material time receive the price which is fixed by the central government with the add-ons fixed by the state government. Even if the oil company like IOCL fixes an independent price, it will not receive the same for the quantity sold and distributed through PDS unless the government declares the same to be the price. In the order impugned, there is no discussion in this respect. The learned single judge has, in an omnibus manner, restrained the oil company, restrained IOCL from enhancing the price over and above that which was prevailing in September 2020. The price of kerosene bracket SKO is dependent on the market rate. It therefore fluctuates depending upon the price in the international market, refining costs, currency exchange rate, as also the taxes. The oil company, therefore, cannot be restrained from fixing a base price of itself. Whether the oil company will get such price for the quantity sold through PDS is dependent on the declared price of the central government with the add-ons decided by the state government. So it is inconsequential whether the oil company, in the instant case IOCL, enhances its price as at the end of the day for sale through PDS with which we are concerned, the price declared by the central government will be the receivable price along with the add-ons as fixed by the state government. We therefore modify the order dated 13th October 2023 to the extent that the appellant, being the respondent number 1 in the writ petition, being WPA 24540 of 2023, shall be free to decide on its base price, but will receive only the declared price of the central government along with the add-ons of the state from as may be fixed from time to time.
And the whole dispute today is this central government not fixing the law. Shall give a time frame? The central government to fix the price, then save both of us.
There is already a direction on 12.
There is no time frame.
There is no time frame. So
That is why till then what happens?
It is expected that the central government, as directed by the order dated 12 September 2023, shall as expeditiously as possible fix the declared price under article, that is article or control order?
No, control order. 2D of the restriction on kerosene.
No. It will be defined as article 2D or
no clause.
It should be clause.
Clause
2 subsection D.
2 bracketed D.
Clause.
2D, clause 2D of the 1993 control order. Nothing further remains to be decided in this appeal. The appeal is accordingly disposed of. Parties will be free to agitate all other points in the
writ petition. And other part of the order is not disturbed. There are other part also.
There may be some correction I have dictated in. I will try to make.
Only Lordship, only one thing,
Make it urgent.
Lordship has dictated the order. Only one thing I'd like to point that Lordship said that they will be free to fix the price.
Base price, base price.
Even base price has to be fixed by the central
That
government.
term is ex-depot. Ex-depot price. Can you make that?
So they cannot fix the price at all under the control order.
See, on
They can fix only for open market operations, not for PDS.
Mr.
If we don't fix, there will be no sale of PDS.
Mr. Sarkar, who will fix the scale of fee or memorandum of fees? You will fix yours. Now, whether the client will give it to you or not,
that is
his prerogative.
now as a now as a senior advocate, you have the scope of pro bono service. This PDS is something like pro bono.
Grateful to my lord.
Well, only one thing, well, this order should not be in conflict with the earlier order from which there is no appeal. But there, the single judge has already held that the oil companies cannot determine the PDS price.
Finding.
Yes, that's the finding, my lord.
Should have said to frame a policy.
Twice, yes.
In terms of my order, that is not there.
Lordship, otherwise that order becomes infructuous.
Very well.
Lordship.
My lord, I apologize unconditionally, my lord. Item number 245. The moment my lord has taken up 92, I was my lord, standing in outside. My junior has called me. By that time, my lord, I was told.
It's too late, Mr. Basu. You take your chance next.
My lord, I understand, my lord. Lordships have my lord.
Yes, arakta fixed to
all other matters released. 254 I was mentioning from the morning.
Well, I made a mistake.
All other matters is released.
I made a mistake, Malad, since I'm appearing after Holy Bijaya. Malad, may I wish happy Bijaya to your lordships and also lordships court officers.
We reciprocate the same.
My lord said the same thing first thing in the morning.
My lord, may I only request, my lord, it's my mistake. Client may not suffer, my lord, in any way, my lord, it's our.
They are not suffering. Tomorrow you will be taken. It will be.
But only the thing is that the mine cannot be continued, the mining work, and they have, my lord, given me a threat of termination. Tomorrow, my lord, is a time, my lord, fixed at 11:30. I understand, lordships, but I will be waiting, my lord, after you lordship have fixed up the other two matter or one matter. If lordships, my lord, business permit, my lord, then, my lord, I may take chance, my lord. If may I wait, my lord.
Let us see.
Very well, but I am waiting, but I am deeply up.
যেটা আরেকটা মেনশন করেছিল
all other matter 254 except the matter which is fixed.
You want to go back home?
254 minute, the order under appeal.
Who is stopping you? I will in the vacation bench. Nothing is dismissed.
Mr. Topon Mukherjee is opposing.
My lord, Mr. Mukherjee was here until 4:40. Then he left, my lord.
Yes,
He was here. He's now giving city office.
My lord, only immediate urgency is this. Now, please come to page 46. Page 46. My lord, kindly seize the dates. My lord, yesterday, 9, column 9. Online bid opening date for technical proposals was 7th November. My lord, this last two, 8 and 9 has not yet happened. My lord, I was only beseeching your lordship, I shall come back to the regular bench on the 16th, 17th. My lord, till such time, nothing should be done. Why? Because, my lord, I am, my lord, agitating this problem. My lord, first see, my lord, the previous, in the matter, when the matter was first moved before your lordship's court, my lord, at page 129, this is the order made by your lordship's court. Page 129.
Got it.
This was 129 is the first order. They were supposed to come back with instructions on the 1st of November, instead of calling for instructions, the Honorable Single Judge, I took leave on the 1st of November itself before the division bench. This was the order made by His Lordship, on the 1st. at least 100% of the quoted quantity of the similar goods and or services meeting major specification parameters which as is functioning preferably in a government hospital. The petitioner has assailed this clause by pleading that the petitioner is being prejudiced by the unlawful, malafide and arbitrary act of the authorities, particularly this hospital, and as such, this clause is tailor-made to suit some handful contractors. Now, please see the clause.
My lord, sorry to interrupt, my lord. She have informed Mr. Mukherjee and he has asked to fix it tomorrow, my lord. He left after 4:40. He left the court.
But he was informed. His junior was informed. Mrs. Kindly let the matter. I do not mind tomorrow. Till tomorrow, nothing is to be done, and tomorrow let it be fixed. Absolutely at the top.
No problem. No.
Since they are paying for an accommodation,
we are not
I want to do the matter. I was just drawing your lordship's attention to page 63.
Very well. Take down.
Kindly pass an order so that it is taken up tomorrow at the top.
The matter was mentioned in the morning for being taken up out of turn, citing the urgency as the petitioner or petitioners.
Petitioner.
As the petitioner is challenge as the appellant petitioner is challenging an order which relates to a tender process.
Mr. Mukherjee is here. Well, if he wants tomorrow, I do not mind. If he wants today, I'm just saying that this is the clause. All other hospitals have a different clause. Why was this clause particularly?
Mr. Mukherjee, since you were not there, what we were proposing that let it be taken up tomorrow till tomorrow or day after tomorrow. You do not take any steps.
No, but his grievance is that 100% credibility. But so far as this particular medical college is about 1100 beds, 876 sanctioned, but running bed is 800. And other colleges were not below 500 or 600. And that's why he has not participated in the pre-bid meeting. And the pursuant to the interim order refused by the learned judges, they have proceeded. Now, if he wants to participate, if ultimately conclusion that we will issue another notice, he could have participated in the pre-bid meeting, that this is my grievance. He has not participated in the pre-bid meeting. That's my instructions, and I've got the written information that he has not participated in the pre-bid meeting.
That is not the instruction sought for, my lord. With deepest of respect to my learned senior friend, the instruction that was sought for from the end of the government is why was a special clause like page 63, column 6, particularly incorporated in this particular tender as against the other government hospitals and facilities, where it is restricted to 40% of the eligibility. Why 100% in Postim Medni?
Why this about
they could have, without nothing, they just wanted to, steamroll me.
No.
100% will be full.
100%
tenderers.
Very well. কি বলেছি দেখি
তোমরা ব্রিফটাও কেউ রাখো না।
এই তো সঙ্গীতা ছিল তো,
আমি তো নেই
ছোট্ট আসছে ব্রিফ বন্ধ।
সঙ্গীতা তো
in respect of supplies.
This is for cleaning and housekeeping and scavenging services. Page 46. Minor Justice Chaudhary, page 46.
তোমরা কি করো না তো? তোমাদের ব্রিফ হয়েছে।
Serial number 6 and 7.
Yes, we are last date for up to 8 stages, 9 stages over. 10 and 11, let them lay their hands and not do anything, till the matter is next heard.
Single judge has refused according principle talk to me, they have proceeded with matter.
Yes, they have proceeded up to the 9th stage. 10th and 11th is not done.
Just a minute.
No, your lordship, the essential service to the patient.
Yes, yes. Please wait. Let us dictate the order. হ্যাঁ কি বললাম
আসো কোথায় তুমি কোথায়
tender tender process. The notice inviting e-tender
হয়ে যাচ্ছিল তখন বলাতে কালকে ফিক্স করে
for e-tender call for cleaning and housekeeping oblique excavenging services at Midnapur Medical College and Hospital
তোমাদের তো স্ট্র্যাটেজি যেটা
dated 30th September 2023. Hereinafter referred to as the said tender is challenged on the ground that the government has imposed such stringent condition that ordinary suppliers like the petitioner are eliminated with the intent to allow some big organization to obtain the supply as such organizations can only fix such or can only fulfill such conditions. It is also the case of the appellant that in all other hospitals,
Page 115, kindly sees 116.
all
116.
other in all other I will record, Mr. Mukherjee, I will record in all other hospitals.
Page 116, stop. 116, stop.
What is the number of beds?
116, stop.
Medical College,
40%. অন্য টেন্ডার দেখি কানে দেখি
ওরা কিসের জন্য ব্রিজ নাও কিসের জন্য একটাই ব্রেক হতে পারে না তোমার ব্রিজটা কোথায় একটা আমার একটা তোমার জুনিয়র ব্রিজ পড়ো না কিছু না
The tenderer should produce credential of similar nature of a completed single work having minimum value of 40% of the estimated amount put under during 3 years prior to the date of issue of the e-tender. While in case of the subject tender, in case of the said tender, 100%
Jharkhand Medical College, 40%.
No, his capacity is 1100 beds.
Ask him.
Mr. Chaudhary will not lost 7 kindly.
100% of the estimated amount has to be fulfilled. Full stop. The petitioner says that the tender conditions are such that it violates the provisions of Article 19(1)(g) of the Constitution of India. The petitioner therefore says that he should be permitted to participate in the tender, and till such time the steps and or further steps to be taken in terms of the said tender should remain state. Full stop. On behalf of state, it is submitted that the hospital concerned in view of its size and operation on the basis of operational beds require the terms as fixed in the said tender to be complied with. The terms referred to by the petitioner in respect of other hospital do not fall under the same category. That apart, the tender conditions, that apart, the fixation of tender conditions is a prerogative of the state under the policy decision. Pursuant to the impugned order, the respondent state, pursuant to the impugned order, the state has proceeded further with the tender process.
And up to the technical bid opening stage, may not page 46. I'm sorry.
The proceeded with further. The petitioner also did not appear at the pre-bid meeting to ventilate his grievances. The matter requires to be scrutinized in details as it relates to distribution of largesse by the state. The state cannot act arbitrarily to give additional benefit to a group of suppliers. At the same time, the power of the state for fixing the conditions cannot also be curtailed unless it is arbitrary. The interference into the tender process, which involves several economic and technical parameters is seldom made as the conditions are fixed by expert bodies after delving upon the requirement. Full stop. The tender has not proceeded beyond opening of the tender,
Technical bid.
opening of the technical bid,
Yesterday it was open, Milord. Yesterday.
which had been open,
10 a.m.
Which has been opened on 7th
At 10 a.m. Page 46.
10 a.m. On 7th November 2023. Post. The writ petition is pending.
No, writ petition is dismissed.
Oh, sorry. The second order
Yes. The order under appeal.
The writ petition has been disposed of, has been dismissed by the order impelled. It is therefore necessary to strike a balance in the matter in the light of the discussion as aforesaid. It is also to be noted that necessities in respect of a hospital cannot wait eternally. In the aforesaid facts and circumstances, the state may proceed with the tender process, but should not award the same before deciding the grievances of the petitioner by a reasoned order. The state shall, within a fortnight from date, call the petitioner by a notice in writing to attend a meeting for considering the grievances of the petitioner. The আচ্ছা ওটা কবে ডেট দিলাম বলো তো, নাহলে বিশ্বরূপের মক্কে ওইটা নিয়ে চুপ করে বসে থাকবে আর সাপ্লাই আর হবে না। হ্যাঁ কি বলেছি
Your Lordship may kindly lessen it by another fortnight. Instead of fortnight, 10 days. 10 days is better.
There is a
within
tender.
7 days করে দাও।
Yes.
All ইয়ে।
7 days is a festive season is going on. 7 days is Kali Pujo is 12. Bhaipota up to Bhaipota everything is closed.
But there is a tender committee is there.
Yes, tender.
Yeah, the state government tender, whatever the tender committee.
Tender committee.
Yes, কি বললাম তাহলে?
Headed by the principal of the medical
the
college.
Tender committee concerned with the said tender shall, within 7 days, inform the petitioner in writing a date
for hearing
of hearing which should be after 14th November 2023.
Great, great, no problem. Great.
To consider the grievances and shall thereafter communicate the reasoned order to the petitioner.
My lord, the petitioner will be permitted to raise all points, my lord. Canvass all points. My lord, kindly clarify. Otherwise, they will say that the court's order did not say it. You are not permitted to give a written representation. My lord, the state may, my lord, invent all these, my lord.
Very well, I will look into that.
After all, they are medical officers.
I will look into that. Nothing further remains to be adjudicated in the appeal.
The appeal is treated as on days list and disposed.
And is treated as on days list by consent of parties and is
disposed
accordingly disposed of.
Great.
May I provide extreme instances? Just not with your lordship. Can it be uploaded by tomorrow or there?
It will be uploaded today itself because we will not be available after say 7:30, 8 o'clock today.
No, I was under the impression, my lord, after leaving the court.
না আমাদের এদের মামলা আছে চয়ন গুপ্ত মামলা করবে এখন চলো সৌনক মিত্র এসে গেছে দেখো ভাই নাও গেটফুল টু লজ
Grateful to lord.
অরিজিনাল সাইড অফ একটাই তো অরিজিনাল সাইডে দেয়া আছে। No further appellate side matters.
All right, number 240.
It's already 5:10. I have granted leave in one matter in the original side. That has to be taken. Please consider our case and the.
I understand, my lord, I would not take more than 10 minutes. My lord, the problem is, my lord, by the order of the impugned, the learned judge, my lord, with the deepest of respect, has left me nowhere.
No point.
Learned
Mr.
judge has
Basu,
said that.
No point in repetition.
I know, my lord, I am extremely sorry, my lord. If, my lord,
Point in-
my lord, after this matter, I would, may I take 5 minutes of your lordship's time?
It won't be possible. See, they have to transcribe. We have to. Don't you want us to leave the court by
I shall not, lordship.
hour?
My lord, I shall not. But the predicament, my lord, that my lord compels me, my lord.
Tomorrow.
My lord, tomorrow they have given a time at 11:30, my lord. And if
10:30 the court will sit.
My lord.
না না মিস্টার আবু আজকে শুনে নিতে বলছে এখন 5:10
only I will not take more than 10 minutes. If my lord, by the clock, if 10 minutes.
কালকে থাকবে
But my lord, the problem is, my lord, again, my lord, the same.
হ্যাঁ হ্যাঁ লিস্টে
The problem is, lordship has already considered, my lord, there is only one division bench, my lord, with the all criminal and civil matters, my lord.
Let us hear the next matter.
Lord, I'm led by Mr. Krishnaraj Thakkar, my lord. He has joined online, my lord.
No, we won't give him that liberty. Why?
No,
everybody will come physically and he will enjoy.
He is not in.
My
this.
lord, kindly permit me, my lord. I have come for a matter, my lord, in another court, my lord, outside the city, my lord. If your lordship kindly permits me.
You will be in Bombay, Delhi, and.
Yes, my lord. The other courts are now shutting, my lord. On 10th, my lord, is the last working day. Yes, my lord.
Very well. What is the matter about?
My lord, it's a very short matter, my lord. By the order of 19th, I am the contributory, my lord. This relates to certain assets of Dunlop India Limited, which is in liquidation. My lord, I am one of the contributories of Dunlop India Limited. By an order,
Dunlop is still on board.
Yes, my lord, it is still at the stage of liquidation. I am still trying to revive the company, my lord, but that is subject matter of a review which is pending. So I'm not troubling you with those facts, my lord. Now the fact of the matter is, my lord, since I don't have a stay in the review, the company court, my lord, is proceeding with sale of the assets of the company in liquidation. Now, by an order of 19th October, which your lordship will find at page 16.
Mr. Thakkar, if you don't have a stay in the review, where is the embargo in proceeding with?
Yes, my lord. Your lordship is my lord. I bow down to your lordships, my lord. There is no, as such, there is no embargo in carrying out sale, but the sale has to be carried out in a manner which is known to law, my lord, and which is, my lord, in accordance with the settled legal procedure. A sale cannot be carried out in a manner which is unknown to law and contrary to the settled legal procedure, my lord. At page 16, your lordship will find of my stay application, the impugned order of 16th October 2020, 19th October 2023. Now, my lord, this order contains two directions, my lord. The order contains two directions. I find, my lord, that there was one company by the name of Salasar, which is mentioned here, which claimed to be 50% owner of one particular building, and Dunlop is the owner of the other 50%. But there's one company called Eyelid who has a, I don't know, some stake there. They are contending that they have some stake. Be that as it may, my lord, court has directed the sale to be conducted. Now, I am on two things, my lord. Kindly come to page 18, please, my lord.
Mr. Kakkar, please allow us to go through the order.
I'm sorry, my lord. Please, 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 my lord.
Yes. What was the order? What was the order passed in the review? You said
The order made in the review, my lord, the order made in the review is that any proceedings in the company petition will abide by the review. Kindly come to page 50, please, my lord. 50. Kindly, and at page 51, your lordship will find the operative portion. The court has noticed that there appears to be some delay, but then any steps, I'm sorry, ma'am. So to that extent, my lord, I am protected. Now your lordship has seen the order impugned. If I succeed in the review, of course, everything will go being protected by this order. Your lordship has seen
the thing which we are asking, who is for the official liquidator?
I'm for the official liquidator, your lordship. Point is, your lordship,
The point is simple. Point is, why didn't you place about this review application before the court?
Lordship,
the good, bad, indifferent. What have you done with the review application?
Lordship, review application, Lordship.
He may choose. It suits him. He may choose. He will not proceed with the review application.
But
so, as an official liquidator, you are the custodian of the company in liquidation. You are to collect the assets. You have to distribute it. What have you done?
Lordship, may I make some humble submission before your lordship? The impugned order that is 19th October, your lordship, that was the sale by eyelid. And subsequently, your lordship, the honorable coordinate bench has been pleased to decline the order or prayer of eyelid, your lordship, and accordingly, your lordship, we have proceeded with the sale. But unfortunately, we couldn't get the very highest bidder, so therefore the sale proceed will be again been fixed on 10th. This is the position of your lordship. And apart from it, your lordship, this appeal is at this juncture is not at all maintainable, your lordship, because they have come at a very belated state. The proceeding is continuing before the learned single bench, honorable single bench for quite a long time. They could have approached. They are what their appeal is that.
I am not aware of what appeal my learned friend is to.
You are a statutory authority. His client is a private litigant. He can choose, he can blow hot and cold at the same time. No difficulty. We have seen many things in respect of company in liquidation. But what prevented you? Why will you not bring to the notice of the court that look here, there is a review.
But your lordship, there has been no stay granted by the honorable.
See the review.
There has been no stay, and this review application is pending, your lordship.
Nothing is pending. Review is not born yet. What prevented you from assailing that order?
Only thing, Lord, that is a subsequent to the order which has been placed before your lordships. But an application was filed by the review applicant seeking to stay the sale of movable assets. But the honorable coordinate bench has been not giving remarks against the same applicant. Please have a look at this.
Yes, so my lord, my lord, kindly permit me to complete my submissions, my lord, because I am slightly handicapped on the virtual net platform.
Same applicant.
Mr. Mojumdar perhaps appears for Salasar, if I'm not wrong.
Yes.
This review application is the same review application.
Same review application.
Yes, yes.
Movable assets, this is for an immovable asset. Please see note review number at the top.
Yes. Now, Mr. Thakkar, what are your grounds?
Yes, my lord, my grounds are twofold, my lord. I have not tried to suppress from your lordship, my lord, that I am not enjoying it, that I'm enjoying any stay or that the sale should not proceed because of pendency of the review. That is not my case before your lordship, my lord. My case before your lordship, as I said, is that the procedure for sale, if it is contra the settled procedure or the law laid down by the land court or law laid down by your lordships, my lord, then that sale procedure is bad. The sale is a nullity. For this, my lord, kindly come to page 18 once, please, my lord. Kindly come to page 18 of the impugned order itself. The learned judge.
The notice has been published.
Auction. It
On
is
20, the sale notice came out, perhaps, my lord, on 26, from which I came to learn that this is a sale which is being conducted. 26th of October, the sale notice came out. Then I made inquiries and then I've come up before your lordship. My lord, two things, my lord. Kindly just see, my lord.
come up with all the papers, your lordship, because in the afternoon I have been instructed to appear. They have sought leave today in the morning.
Sale notice is annexed, my lord. The sale notice is annexed. Kindly see the sale notice once. I will only argue on a pure question of law, my lord. I will not go into any disputed fact. Kindly once see page 18 once, please, my lord. The order impugned. Kindly see page 18 once, please, my lord.
Yes, I have seen that.
Page 18, your lordship will kindly see second sentence, second paragraph on that page, the last sentence. Now, my lord, kindly see this. Since the valuation of the property, my lord, has that, my lord, towards the right hand side. Since the valuation of the property and the advertisement for sale has been done more than 2 years back, the OL shall take steps for selling this property within 3 weeks from today. So, Mala, the sale is proceeding on a valuation which is done 2 years ago. The learned single judge is conscious of the fact, but the learned single judge said that because this valuation is 2 years ago, you must sell it within 3 weeks. This can hardly be a justification, my lord, for fixing a reserve price on the basis of valuation which is done 2 years ago in case of immovable property. Number one. Number two, my lord, the sale is directed to be done by public auction. Kindly see the company code rules once, please, my lord. Two rules of the company code, and I will take your lordship to two judgments and I'll close my submissions, my lord. I don't want to take up your lordship's time at 5:30. But kindly see the company code rules once, please, my lord.
Which rule? Which rule?
Mr. Gupta, please hand over the rules. 272, 272 and 273. 273, my lord. That is all. 273 and rule 6. Mr. Gupta, please hand over copies of Rule 270. I'm sorry, Malad. There is only one book I can see. I'm sorry, Malad.
There is one other. There is one other printer.
Okay. Kindly come to Rule 273, please, Malad. These are the company court rules, 1959. These 272 and 273 deal with sale by official liquidator, which is what is being done now. Yes. Unless the court otherwise orders. No property belonging to the company which is being wound up by the court shall be sold by the official liquidator without the previous sanction of the court, and every sale shall be subject to confirmation by the court. Now 273, this is the only procedure which is prescribed. Every sale shall be held by the official liquidator, or if the judge shall so direct, by an agent or an auctioneer approved by the court, and subject to such terms and conditions, if any, as may be approved by the court. All sales shall be made by public auction or by inviting sealed tender or in such manners as the judge may direct. So, this is the general rule. 273 says to be done by public auction and on such terms and conditions as the court may direct. In the order impugned, no terms and conditions have been laid out by the learned single judge other than saying that it is to be done by public auction on a particular platform. Kindly take Rule 6 once, please, of these rules, my lord. Rule 6 of the Company Code rules specifically provides that the provisions of the Civil Procedure Code are to apply. Kindly may I trouble your lordship with Rule 6 once, please, my lord, of these rules. That
Mr. Thakkar, this Rule 6 and 9 at one time was a part of the cause title in winding up proceedings.
Yes, my lord. Absolutely correct, my lord.
6 and 9 is known. 259.
So, my lord, may I just, my lord, for my satisfaction, may I just place Rule 6 once, please, my lord. Save as provided by the Act or by these rules, the practice and procedure of the court and the provisions of the code as far as applicable shall apply to all proceedings under the Act and these rules. So, my lord, the code has been made applicable unless there is anything to the contrary given in the Act and the rules. I have shown your lordship Rule 273. Now, my lord, Order 21, Rule 84 and Order 21, Rule 85 of the Code of Civil Procedure deal with sale of immovable property. Order 21, Rule 84 says that immediately upon sale being confirmed in favor of the highest bidder, 25% of the money has to be deposited. Order 21, Rule 85 says 15 days from the date of sale confirmation, money has to be paid. These two rules, my lord, were the subject matter of consideration before a very recent judgment of the Supreme Court, my lord, 2023 6 SCC 391, where the Supreme Court referred to a larger 3-bench judgment of 1954 and held that these rules are mandatory. Any sale held in violation of these rules or not in compliance with these rules is null and void, non est illegality. Mr. Gupta will just hand over to your lordship, my lord, the two decisions. This is well settled, going back as in 54, followed as in 2023. And now your lordship sees the sale conditions which have been framed by the official liquidator, which have not been approved by the court by the order impugned. There is flagrant violation of the mandatory provision. Kindly see, my lord, 2023 6 SCC, if your lordship has that, my lord. Kindly come to paragraph 11.
Mr. Thakkar, this is not required. This is not required. Mandatory provision to Order 21.
Yes, my lord, sale is a nullity.
Provisions of Order 21 is embedded with the company rules in view of 6 and 9.
Grateful, my lord. Kindly only see paragraph 31 then, my lord. The Supreme Court considers the provisions of Order 21, Rule 84 and paragraph 23 onwards, my lord. Then it considers paragraph 28, the 3-bench judgment of the Supreme Court, which I was referring to, and a subsequent 2-bench judgment in paragraph 29. Then, my lord, kindly see paragraph 31. Applying the law laid down by this court in the aforesaid decisions to the facts of the case in hand, it is evident that there is non-compliance of mandatory provisions and therefore the sale was vitiated. And the sale which was held and confirmed by the court below was set aside as being a nullity. Now, I'm going to kindly see the sale notice which is published here.
That is what I had asked you.
I'm so sorry, my lord. Page 91, my lord. I'm sorry for taking up your lordship's time, my lord. Sale notice starts at page 85, please, my lord.
Yes.
The sale notice at page 85, my lord. Kindly see there's a provision for earnest money deposit of 20% at page 85. In the box in the middle of the page, my lord.
Yes.
This is the earnest money to be deposited along with the offer price. Now, my lord, kindly comes to page 91, where the, my lord, infraction occurs, my lord. Kindly come to 91, please, my lord. 8.3. Once the bid is accepted by the Honorable High Court, this is the e-auction site, my lord, will transfer the amount of the EMD to the account of the official liquidator. Then, my lord, 8.4, 25% of the bid amount to be deposited with the OL Calcutta by the successful bidder within 7 days from the date of acceptance of H1 bid by Honorable Court, failing which the pre-deposit EMD shall be forfeited. So, my lord, this is an infraction of 2184. It has to be done immediately. Number 2, my lord, kindly see 8.5. The entire due balance payment will have to be paid by the successful bidder to the official liquidator within 30 days of acceptance of H1 bid. The buyer shall adjust the pre-deposit EMD with this payment. So, my lord, 30 days is again an infraction of mandatory order 21 rule 85, which says 15 days. So, any sale which the OL proposes to hold pursuant to this sale notice will be a nullity.
Very well.
Now, my lord, my lord, A is the on the aspect of valuation, my lord, it is proceeding on a valuation which is more than 2 years old. That itself is bad, my lord. A sale of immovable property on the basis of a valuation which is more than 2 years old, which the learned single judge notices, but says that because this is 2 years old, you hold it within 3 weeks. That cannot cure the, my lord, the defect of the valuation being 2 years old. My lord, I can do it within 2 days, but I proceed on a reserve price which is 2 years old. Well, that makes the sale vitiated, and then there is clear infraction of the mandatory provisions of law, as laid down by the Supreme Court. Sale is a nullity. So, if Mr. Mojumdar's client, I understand, is very interested to participate in the sale and grab the property, but it will be a wasted process and will only delay the liquidation. Number 1. Number 2, the second direction which is given there is, your lordship has seen in the impugned order, for payouts to the workers, disbursal to the workers. This is to be done by January. I have no difficulty with this, but apropos this, also kindly consider 2 rules of the company code rules and kindly direct the official liquidator to act in terms of these rules. He cannot do it any other way. Kindly take rule 167, please, of the rules, company code rules. He is doing it without following the rules. The learned single judge is taken a very pragmatic view because of the delay and the sufferings of the people. So I can't possibly say that payment should not be made, but then the rules under 167, 168, 169 and 174 have to be complied with, my lord. Kindly see 167, please, my lord. Kindly see rule 167, please.
Yes.
Proofs and list of creditors to be filed in court. In a winding up by the court, the official liquidator shall, within 3 months from the date fixed for the submission of proofs under Rule 147, or as such further time, file in court a certificate in form number 171 containing a list of the creditors who submitted to him proofs of their claims in pursuance of the advertisement notices and such and such. So, this has to be done. This has not been done yet. Then kindly see 168. The list as certified by the official liquidator and filed in court shall be the list of the creditors and shall not be added to or varied except under orders of court and in accordance when an order is made, varying, etc. So, my lord, this has yet not been done, my lord. Then notice of, then I kindly see 169. I am entitled to a copy of this. Upon the filing of the certificate containing the list of creditors as settled by the official liquidator, the registrar shall notify the filing thereof on the court notice board, and the certificate and the list of creditors as settled and the proofs relating thereto shall be open to the inspection of every creditor or contributory on payment of a fee of 1 rupee. This has also not been done. He has not.
Mr. Thakkar, my lords are discussing. Please.
I'm so sorry. I'm so sorry.
167, 160.
167, 168, 169, and kindly also see 174. After all this is done and the contributories are given an opportunity, my lord, to deal with this list of creditors which the OL has finalized, my lord, then only the court makes a final order on settlement. Kindly see 174. On
See.
the date, I'm sorry, my lord.
Yes.
On the date fixed or on any adjourned date, the court shall, after hearing such evidence as may be tendered, adjudicate upon the claims and settle the list of creditors. The settlement of the list of creditors shall be recorded in a certificate signed by the judge in form number 75. And then 175 says the list of creditors as settled and the proofs file shall be open to the inspection of every creditor and contributory on a payment of fee of 1 rupee. Well, nothing has been done in this matter. The OL Malad has got 44 crores. He wants to dole it out. I can understand the learned single judge's anxiety that poor workmen should not suffer, but the procedure laid down in law has to be followed. Kindly direct the OL to comply with these mandatory rules. And Malad, this sale, Malad, should be set aside. Because this sale notice is bad. The Supreme Court says sale is a nullity pursuant to this.
Yes.
What are my respective submissions, ma'am?
Yes. Anything?
Lordship, one more thing I would like to add, Your Lordship. What I instruction I have received, Your Lordship, that in this appeal, the appellant has referred the appellant to be the contributory, but the appellant has placed a claim before the official liquidator as a creditor. And apart from this, Your Lordship, this appeal at this juncture is not at all maintainable, and the appellant at this juncture has got no locus standi to argue all this. He is challenging the sale proceeding. He is challenging the manner the official liquidator is functioning, but that procedures cannot be challenged this manner in way of an appeal, Your Lordship. The review application that is pending since 2021, that he ought to have completed by this. Now, at least he ought to have approached before the learned single judge, intimating and initiating what steps have been taken in the review proceeding, Your Lordship. So this appeal, Your Lordship, is not at all maintainable. And apart from this, Your Lordship, already we have, regarding the sale proceeds, regarding the movable properties of Chennai and this other state, we have already proceeded. This matter, Your Lordship, 7th was the date, next date is on 10th.
Mr. Mujumdar, you have nothing to say?
You
are a participant.
Yes, not a very few sentences to say. Not the court is really trying to prevent the abuse of the process of court in terms of rules, 9 of the self-same rules probably.
But at the same time, further abuse cannot be.
What is the further abuse? Not please have a look at that notice of auction. Of course, not the sale will be finalized by the court. Now kindly have a look at the auction notice. It's going on since February 2021. Please see clause number 9.
Page?
I'm sorry. That's clause number 8. Clause 8. Now there is a broad caption: acceptance of the highest H1 bid.
Yes. Till now, Mr. Mujumdar, are you the highest?
But I had been asked to match the highest bidder because I am claiming a preemptory right over the property, 50% share.
You are for Salazar.
I am for Salazar. But that was an order passed in February 2021 when this Honorable Court directed my client to match the highest bidder in the auction.
At this stage, you don't have much to say. I don't think.
To the extent of this auction,
I thought you were appearing for the workers.
I was.
Workers have not been included as a party also.
See, Mr. Thakkar's client is probably not aggrieved with the payment directed to the worker, except that it should be done in compliance with the statutory. That Mr. Mujumdar is in a much better footing to say, because unless it is the statutory requirement is complied,
gratuity and other claims,
everything will become. Instead of aiding to the workers, it will be putting them into further difficulties. As it is, we do not know how many workers of Dunlop are still alive.
On the other day, as the submission was being advanced, I am told it's around 2,200 in Shahaganj and the South India, Ambattur factory.
That is recorded also.
That's recorded in one of the orders. Number acceptance of highest bid is subject to approval or confirmation by the High Court. That's clearly spelled out in 8.1. Each and every clause of clause 8 of the principal clause 8 that your lordships may be pleased to take into consideration.
Mr. Mujumdar.
Yes.
You cannot avoid the rigors of Nazir Ahmed principle.
Correct.
The statute provides for doing a thing on a particular manner. It has to be done in that manner. CPC says you have to do it.
Please see order 21, rule 64, 1.
84.
Power to order property attached to be sold and proceeds to be paid to person entitled.
Not attached. This is not attached.
Correct. Not it's, these are the provisions not for sale of properties. Not please have a sale of movable property. There is a subchapter and please see sale of immovable property. What court may order sale? Please have a look at 85. Time for payment in full of purchase money. That's what he's complaining of. The full amount of purchase money payable shall be paid by the purchaser into the court before the court closes on the 15th day from the sale of the property. Now, here is a special provision in the rules in 272. The sale can only be said to be completed once the court confirms the sale.
Always in execution also.
That's right.
If it is a sale in execution, unless the court grants you the sale certificate, it is not complete. You go for any any sale in this under the surface of the debts recovery tribunal, it is the sale certificate.
Unless it is confirmed.
And see, there you don't require a conveyance also. Under the Stamp Act, the sale certificate, if it is registered, it amounts to a title document.
I'm not. What is 85? It's time for payment in full of purchase money. That's what he was complaining about.
Very well.
So that as of today, and please see the division bench order once, which was carried up in appeal. But the court said very well the Honorable Single Judge will ultimately decide on the auction to be taken place. The court will finalize the sale. Thereafter, the question of putting in the money will arise. Not reading two provisions, 272 and Rule 85 conjunctively.
Majumdar, the difficulty is that we are in the vacation bench. Yes. We are not the regular bench. If we are in the regular bench, we can look into all these things. My learned brother will be probably part of the regular bench if there is no change in return. Let him decide as part of that bench. Now let us pass an order.
Today, not at the instance of the applicant, it's my most respectful submission that the e-auction should not be stalled. And not who is, it's the alter ego of eyelid. He is an alter ego of eyelid, apropos eyelid. I mean Dunlop. He's an associate company of Dunlop.
Eyeball.
Eyelid Mercantile.
No, alter ego of eyelid is eyeball.
Could be. If not retina or corona, something. I don't want to spell corona. Cornea is. But be that as it may, at whose instance this application is being made and for what?
Mr. Mujumdar's client doesn't have any locus to oppose this appeal. He is an interested purchaser.
All these
he has
points.
no locus, my lord.
At my instance, the matter got moved. In my application, these orders were passed.
Yes, take down. The more we look into the matter, the more we are astonished regarding the manner in which the official liquidator has conducted itself in dealing with a company in liquidation, which is none other than Dunlop India Limited. The products of which joined the roads, joined the Indian roads and aviation field over decades. The appellant claims to be a contributory. Although the official liquidator disputes the status of the appellant, but it is prima facie evident that there has been some contribution from the appellant. Before the company went into liquidation. এইটাকে না উপরে দিয়ে দেবে, এই যে ওই যেটা বললাম না মোরবিলগুলো কিন্তু ওটা পরে আসবে, এইটা আগে দিয়ে দাও, ফ্যাক্সটা বলি, তারপর আমি যতটুকু বলছি সেটা আগে দেবে, তারপরে ওটা আসবে। হ্যাঁ, এখন এখন কন্টিনিউ করবো, এটা আগে যাবে, ওটা পরে আসবে, ঠিক আছে? হ্যাঁ, কি বল লাস্টটুকু কি বললাম, লাস্টটুকু জাস্ট thus at this stage the appellant cannot be eliminated from challenging the order impute. The appellant says that by the order dated 19th October 2023 at the 2023, the learned single judge has directed the sale of some of the immovable properties belonging to the company in liquidation as per the list provided by the official liquidator. This order was passed without affording the appellant a right to represent. The official liquidator although was aware about the existence and involvement of the appellant, also did not put the appellant on notice. Thus, the appellant in the stay application has made a prayer for leave to appeal. after considering the facts and circumstances of the case and the nature of the order assailed, we have no doubt in our mind that the appellant is a person aggrieved. Being a person aggrieved, the appellant is granted leave to prefer the instant appeal in terms of prayer A of the stay application, তাই তো? কোনটা prayer A দেখালে তখন সকালে জিজ্ঞেস করলাম যে
My lord, prayer A, only one other indulgence, my lord, if your lordship kindly permits. My lord, the usual undertakings which are there, that was inadvertently omitted, my lord, without the certified copy. We have prepared a supplementary affidavit annexing, my lord, the all the review, all the annexures of the, my lord, review application, and also that prayer has been included in the supplementary. That copy has not been served; it has just now been prepared. My lord, may I file it
That
and
may not
serve?
be acceptable, your lordship, at this juncture.
But that prayer has been included here.
Which prayer?
Prayer, the undertakings prayer, to file it without the certified copy and to include a copy in the paper book, that has not been made inadvertently in the, my lord, application in connection with the appeal. So, my lord, that prayer we have included in the supplementary affidavit, and also, my lord, we have annexed all the annexures, the review application with the annexures. That's the only thing. There's
Those
nothing.
annexures I have to peruse, your lordship. I don't know what is there.
No, the review application with the annexures, without annexures, is what it was annexed in the stay application. So, if your lordship kindly permits, leave, my lord, to file this.
তারপরে হচ্ছে the appellant is granted liberty to file a supplementary affidavit no, not to yet, not yet, not yet. We are not
I'm sorry,
granting
I'm
you
sorry.
leave at as on date.
Oh, I'm sorry. I'm sorry.
Is granted affidavit as prayed for to আচ্ছা এইটাকে কেটে দাও, এইটাকে পড়ে দাও, ঠিক আছে, এটা কেটে দাও, কারণ এখন হ্যাঁ সে অ্যাপ্লিকেশন হচ্ছে, হ্যাঁ এটা আছে, ওটা সকালবেলা আমি দেখেছি, ওই আমি তো ভেবেছিলাম আলাদা অ্যাপ্লিকেশন হবে, না না, leave granted to appellant to file this appeal, order dated, না leave to appeal দিয়েছে, prayer A, তারপরে the appellant, next go, the appellant prays for the appellant also prays for stay of operation of the order dated 19th October 2023. The appellant says that the sale notice was admittedly published কি বললাম the advertisement sorry ওটা সেল নয় the advertisement for the sale has been done admittedly more than 2 years back. The advertisement therefore had been done on basis of a valuation report which is at least 2 years old. The valuation report was also not with the official liquidator, as the order records that the official liquidator is permitted to see the valuation report and take steps by 4:30 p.m. on 19th October 2023. The appellant says that the sale is conducted by the official liquidator in violation of the provisions of section rule 6, rule 273, 272 and rules করে দাও rules 6, 272 and 273 of the companies bracketed code rules 1959, hereafter referred to as the said rules. The appellant further says that in view of the provisions of Order 21, Rule 84 and 85 of the Code of Civil Procedure 1908, are embedded into the said rules in view of the provisions of Rule 6 of the said rules. The appellant refers to the sale notice and says that the time limit prescribed for paying the %25 of the CPC আছে দেখো তো এখানে you have a copy of the CPC?
Yes. Yes, my lord.
The 84, 85 are set out, my lord, in the 2023 Supreme Court also, my lord.
Hmm, 25% of the sale price has to be deposited immediately upon the offer is accepted. Rule 85 of Order 21 says that the entire balance purchase money has to be paid within 15th day from the sale of the property. Referring to the sale notice at page 92. Referring to clause 8.3, 8.4, and 8.5 at pages 91 of the stay application. The of the sale notice at page 91 of the stay application, the appellant says that there is complete violation of the said rules. The appellant then refers to a judgment of the Honorable Supreme Court reported in 2023 6 SCC 391 bracket A Gas Point Petroleum India Limited versus Rajendra Maruthi and others, and submits that these provisions have been held to be mandatory provisions. The appellant therefore concludes that the direction for sale as given in the order impugned is contrary to the well-known legal procedure and in violation of the mandatory provisions. As a consequence whereof, the same should be set aside. The appellant, in respect of the direction given in the order impugned for payment to the worker, says that it has no difficulty in accepting the same, provided there is statutory compliance as required under Rule 167, 168, 169 and Rules 167, 68, 69 and 74 of the said rules. The appellant also says that the official liquidator also did not bring to the notice of the learned single judge that a review application filed by the appellant is pending, wherein on which page is the order, Mr. Gupta? That
The impugned order, well, page 50.
No, that review.
Order left.
On 23rd September 2021.
আচ্ছা, wait.
কি বলেছি তুমি লাস্ট টুকু? Wherein?
Page.
The following direction was given, quote unquote, any steps taken will abide by the result of this application. According to the appellant, the court in session of the review application is the final authority to decide on the sale aspect of the assets of the company in liquidation. Had this order been brought to the notice of the learned single judge, then a different order may have been passed. Next, on behalf of the official liquidator, it is submitted that the appeal is not maintainable as the appellant is not a contributory and have filed claim before the official liquidator as a creditor. The official liquidator also says that though the property was put into auction on 7th November 2023 as directed in the order dated 19th October 2023, but no offer matching the reserve price has been received as yet. Is it your submission?
Lordship, that is it. We have not received the appropriate offer. That is the instruction.
Oh, ঠিক আছে. Matching the reserve price has been received, and as such, the date has been extended till 10th November 2023. The official liquidator also says that the appellant is the appellant has been appellant is a fence sitter and has approached at a related stage to disrupt the sale in terms of the sale to be conducted in terms of the orders of the Next, Mr. Mojumdar learned advocate appears on behalf of Salazar Towers. What is your full this thing? Salazar Towers
Private Limited.
Salazar Towers Private Limited, who claims to be
I am the owner of 50% of the property, and on September 2021, the court directed me, or I mean, permitted me to match the base price.
That's what I am.
For the balance 50%.
কি বললাম? To be 50% owner of the immovable property situate and lying at 46 capital B Chourangi Road, Kolkata. This must be wrong. This is not 7,07,000. It will be 7,17,000 or.
It would be 17.
17 or 16. Must be 16. Park Street Police Station.
Back side 16. Read says 71. 71.
46 भी Chorungi. Chorungi is your lordship, it's 71.
No, but that is backside of Park Street. I mean that.
47 must be near Everest House.
It's possible,
ICICI
no,
building.
73 is that side.
ICICI building. It must be 16. Very well, whatever may be, Kolkata. Sale notice will give the particulars. '71. Mr. Mojumdar further submits that the court by this court by its order dated 21st September 2021 has granted his 24th September, no, 21st September. What is the date of the order?
It's 3rd February 2021.
3rd February 2021 has given his client to match the highest bidder. Full stop. The submissions on behalf of Salazar Towers at this stage is inconsequential unless sale is conducted. However, in view of the winding up proceedings having reached a representative character, we have heard Mr. Mojumdar. But we have heard Salazar Towers. এরপরে ওইটা চলে যাবে more we despite there being specific direction from 2021, the official liquidator did not take any steps to conduct the sale. On the contrary, to complete the sale process. On the contrary, after publishing the sale notice, took no steps till late 2023. The action of the official liquidator in failing to comply with the orders of the court remain unexplained. The court, the learned single judge has correctly recorded her dismay regarding the conduct of the official liquidator. and probably to eliminate any further delay has directed sale of the property on immediate basis. After hearing the parties and considering the materials on record, we are of the view that even if the conduct of the official liquidator is deplorable, sale of the properties of a company in liquidation cannot be conducted in violation of the statutory rules which as held in gas point supra to be mandatory. It is also well settled as in Nazir Ahmed versus the Emperor 36 PV Council লিখে রাখো ওটা কারেক্ট ইয়েটা দিয়ে দাও। If a statute provides for doing a act in a particular manner, the same has to be done in such order or not at all. Huh? Not at all. In the instant case, if the sale is permitted to proceed on the basis of a defective sale notice with a reserve price fixed at least 2 years before, the entire sale process will be subject to challenges and further challenges at subsequent stages, which will not inure to the benefit of any of the stakeholders. The full stop. There is every likelihood that title in a auction sale with embedded defects may not be confirmed subsequently. Full stop. Keeping in mind all these aspects, we are of the view that the appellant has been able to make out a strong prima facie case. So the balance of convenience and convenience is in favor of the appellant and in favor of staying the sale as directed by the order dated 19th October 2023. The stay is also necessary to prevent multiplicity of judicial proceedings and prejudice to the appellant being a stakeholder either in the form of a contributory or a creditor, as the case may be. The order dated 19th November or 19th October 2023 to the effect the direct sale of the immovable properties of the company in liquidation is stayed. So far as payment of the workers are concerned, the same are also required to be made strictly in compliance of the ওই কোম্পানি কোড রুলস যেটা আছে না বলেছি ওটা তোমার কাছে লেখা আছে কি strictly in compliance with the companies within bracket code rules 1959 full stop. The stay shall continue for a period of 3 weeks from date the matter be placed after the puja vacation before the appropriate bench subject to its convenience.
My lord has been pleased to grant stay. In that effect, your lordship, I'm praying to file my affidavit in opposition to the appeal, your lordship, because that is also because they're challenging all the proceeding, your lordship. And we need to come up all the documents.
At this stage, I cannot then, if you want for affidavit in opposition, then I have to grant until disposal of the appeal.
Because I have to controvert the allegations that has been leveled against the official liquidator by way of an opposition, your lordship.
I believe not that can be done before the regular bench also. We have not gone
That
through
can
the
be done.
kind
That
of
can be
direction
done.
by
but-
management to serve a copy of the application on us so that we can all go through this.
The appellant is also permitted to file the supplementary affidavit as paid for before the regular bench when the matter is taken up next with a copy being served to all the stakeholders. It is made clear that the appellant shall serve a copy of this order as also stay application. All stakeholders, if not already served. হ্যাঁ আমি কি করে ডেট দেবো? হ্যাঁ সেটাও হ্যাঁ, আমি তো ডেট দিতে পারবো না। ওই অ্যাপিল কোর্ট শুনবে, কবে শুনবে আমি কি করে দেবো? ভাই আমি ওইটা করতে পারি না, আমি করবো না, অন্য অনেকে করতে পারে, আমি করতে পারি না। এই তো চৌধুরী সাহেবের নলেজে ছিল, যদি সেই বেঞ্চ থাকে। হ্যাঁ
Well, before Myler's rise, I would not travel to that. Myler may take up today, 6:30. Only Myler to this indulgence that may this matter 245 be listed tomorrow, Myler, as a first item, Myler, above the criminal matters. Myler, this much of indulgence, Lordship, if
can I do that? Really, can I do that?
rather,
To honestly,
but only for the
to honestly
purpose of
tell
Myler,
you,
taking the interim protection.
this is the prerogative of the judge concerned. You go and
Lordship.
mention him. You say that this is the situation.
No, this matter is in the list. Only what may I say this? Today I would not travel to Lordship already 6:30. But the
See,
kindly
that we are realizing now, giving Mr. Gupta leave, we have done a great blunder. Now we cannot leave the court before 10 o'clock because the orders have to be corrected, signed.
only in the alternative, if I am just trying to my luck. The civil matters may be upgraded before the criminal matters. At least this much of indulgence, otherwise, again I have to every day, one division bench we are facing really trouble, that but the plight of the honorable division bench, taking up all matters is not possible.
To that extent, we have also added to your rules. We could not take up all the matters, but at least we called your matter.
Lordship, this was my misfortune, that I was standing outside, at least, if tomorrow, very well, Lordship.
দেখো এটা কার ভুল।